Good morning, everyone.
Good morning.
Welcome to another edition of the WILMIC Fall Seminar. Thanks for coming. For those of you here on site, as opposed to those on the web, I just want to make sure you all know that the Wi-Fi network is CSH. The password is Springs1, all lowercase, Springs1. So welcome to all of you. Welcome to those watching on the web. For those of you on the web, you have two links that you can access. One is the material, and the second link is where you can submit a question. That should be right on the lower part of your screen. So feel free to submit a question at any time. We will get those questions and relay them to our moderator and panel, and we'll discuss those and get some responses for you. For those of you here on site, feel free to raise your hand and ask questions or comments at any time, and we'll get rolling. We have two segments today, each about an hour and 15 minutes. We'll go till noon with a break in between, and we'll get rolling. So I will throw it over to our moderator, WILMIC's Vice President of Claims, Sally Anderson.
Good morning, everybody. Welcome. I'm pleased to have you here and pleased to be able to do this today with the people that I have next to me on the podium. I have worked with nearly everybody here fairly extensively, and the best part of all of this is I really like them. Not only are they good lawyers, they're good people. So we're going to start with Michelle Behnke this morning. Michelle has been around. If you don't know her, I'd be shocked because she's been everywhere and done everything. But she's also done this real estate work for a very long time at a very high level. And we're going to start there and talk about some limited scope issues, which I can tell you from my perch as a claims person in a legal malpractice company is getting to be an interesting question, particularly with a new ethics rule about that. And then we're going to let Mark Young talk a little bit about contingencies in real estate contracts, because contingencies, as we all know, are fairly important. Then I have a couple of pet questions I hope we get a chance to discuss that are new and different, like what should a lawyer consider when he or she is asked to just do a deed? So we can talk about that question a little bit, and we'll take a break. And then afterward, we're going to learn a little bit more about TRID, this new, not truth in lending, but something a little different law that's actually in effect and doing things for us right now. So Scott, it's my friend Scott Hutchinson, who I've known forever, and Cheri Hipenbecker, both from Knightberry Title, who have been very generous with their employees to help us to get used to this. And I haven't done a very good job of introducing Mark Young sitting next to me. Mark and I have known each other for so long, I'm afraid to even say. And they're laughing because I was his teacher in high school. He got to be a lawyer before I did, however. So at least I think you did. So that's how far this panel goes back, and that's how well I like these people. Let's get started and have Michelle take us down the limited scope engagement role in real estate.
Well, good morning, everyone. I don't know if when I got the call from Tom, he does this like any veteran person who puts together seminars, rather than specifically asking you to talk about a topic wherein you could somehow wiggle your way out of it by saying you don't know or whatever. He started out with a very, calm, hey, how you doing? What are you seeing going across your desk? And we chatted about a few things, and he said, that would be a great topic for the seminar. So I backed right into this one. So the topic that I told him was limited scope. And I know when I started practicing, I originally started focused on residential real estate, and you got people at the very beginning. You either got a chance to review the offer that was drafted by the realtor, or for sale by owner was getting started, and so you drafted the offer, and you took them from the offer stage all the way through closing, and you handled each of these transactions. More often today, I get the call that says, we're about to close on our house, and everything has been going just great. This has just been a dream transaction. But, I was wondering, or I just thought that maybe we should have somebody just look over everything to make sure that the closing goes okay. And if you've had that call, you probably have the same reaction I do, which is, yeah, right. They only call in that situation because either they're having second thoughts or questions, or perhaps they've now for the first time looked at title and they have no idea what that document is, or more often the case these days, something is actually on the horizon and they don't really want to tell you that World War III is about to get started. The other thing that I see is, even with some of my sophisticated clients, they will say, I don't really want to engage a lawyer until I know that this is going to, kind of really go someplace. And so they handle things themselves or with their friend, and you get the offer afterwards, after everything's all signed, and they just want you to look over the offer, and then they're going to essentially put you on hold while they do the due diligence part until they know, again, that this transaction is going to go okay. But the offer's already signed, and you take a look at it, and you have some questions. You have some suggestions, but it's already a signed deal. So what do you need to know then if you're in that limited scope kind of transaction? And that's really what we're talking about. When you're asked to provide some, but not all of the services that might be involved or that you might normally do, being a good, prudent lawyer. And I've described a couple of variations, but we all know that there are many more. And I will suggest to you that even when somebody comes to you at the very beginning and you outline what the natural scope of the representation would be, and they say yes, somewhere along the line they may change the nature of that representation. And so it doesn't always present as limited scope right at the very beginning. Sometimes it changes along the way. The rules of professional conduct do allow limited scope. SCR 21.2C reads that a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. And so that change came in in 2007. So we've had the right or the ability to engage in limited scope since 2007. But about this time last year, we all were being made aware that there was going to be a slight variation on that rule, and the Supreme Court had a little rule amendment that became effective in January of 2015. After the adoption of SCR, or the Supreme Court Order 13-10, 20:1.2C now reads, a lawyer may limit the scope of representation if the limitation is reasonable, so that's the same, under the circumstances, and the client gives the informed consent, that's the same, and the client's informed consent must be in writing except in some limited circumstances. So they've added this informed consent documented in writing. And I was around when the Supreme Court rules were overhauled back in 2007, and even with respect to engagement letters, there was a lot of discussion about when you needed to do an engagement letter and how you got the client to acknowledge that you had done that engagement letter and things of that nature. And so here, with this limited scope, we have that same kind of issue. How do you document this informed consent? And the Supreme Court has now said that it needs to be in writing, but they give you some exceptions. So I'm going to go through the exceptions first, and then I'm going to go back and talk about reasonableness and the informed consent under the circumstances. So you don't have to have in writing this informed consent if the representation is, the limited scope representation is solely a telephone consultation. right? So they call up and they say, I just want to know if we have 5 days to do X, Y, Z, do you count the first, it's never that easy, but do you count the first day? And you say, yes, you start from the day and you count after that. You don't count the day that you signed it, et cetera. So if that was the limited scope representation, you don't have to have something in writing from the client saying, I am only representing you with respect to this limited scope and this is your question, okay? That's helpful. You also don't have to have that informed consent in writing if the representation is provided by a lawyer employed by or participating in a program sponsored by a nonprofit or a bar association or an accredited law school or a court, and the representation consists solely of providing information and advice or the preparation of court-approved legal forms. So your hotlines, your law day, your clinics at the law school, those kinds of things. So somebody comes and sits in front of my table and they ask me some general questions, hopefully in real estate, because otherwise I have no earthly idea what I'm doing, if it's divorce or custody or something. So that's limited scope, and I don't have to start that conversation by saying, well, just hang on, I'm going to email you my limited scope engagement letter for you to sign. You also don't have to have informed consent in writing if the court appoints the lawyer for a limited purpose and sets forth that appointment in the order. Now, I try desperately never to end up in the courtroom. My knees go weak and I need antacid tablets. But if you were in some representation and you're at the bar kind of that day just for arraignments or something of that nature, and that's the nature of the court's order for your representation, again, you don't have to have that documented in writing. You also don't have to have it in writing if the representation is provided by the state public defenders. Again, not an area I practice in, but you can have very specific, discrete representation, perhaps at the trial level or the appeals level, et cetera. And then the one that I find most interesting and perhaps most troubling, you also do not have to have it in writing if the representation is provided to an existing client pursuant to an existing lawyer-client relationship. When I saw that one, I scratched my head like nobody's business. Because for me, when you think about the nature of limited scope, what you are saying is, I am not going to do the full range of services that I normally would provide. And of all the people in the world who might either have already experienced the full range of services that you provide, or have come to expect you to look out for them, or to say, hey, pay attention to this, or you might want this, or I know in other transactions you normally do this. This is the situation where I think the line is very blurry. If I've previously represented somebody before, and on this particular occasion they are asking for limited scope, I actually think it's the fuzziest. So even though the rule does not require that informed consent in writing, I'm going to suggest to you that's the one situation that I would absolutely get it in writing, because how are you and is the client going to discern the limited scope that they asked you for this time and differentiate that from what you normally do for them? So 5 years after your transaction, when you open the file and you see that you don't have some of the normal things that you normally would do, or you look at the offer and you see that there are not normal contingencies and things are blowing up. I don't know about you, but my memory is not so good these days, and so I'm not sure I would remember why I didn't have the normal things that I normally would do for that client. And I'm pretty sure I'd panic, and I'm pretty sure I would have to call Sally and go, Sally, I don't know what I did here, but I really missed the boat here. Until I dig in the file, hopefully. Yeah. So even though the Supreme Court rule gives an exception there, I'm going to suggest to you that that is one area that I disagree with the rule, and in my practice, if I'm in that situation, I am in fact preparing a limited scope engagement letter. So the Supreme Court rule change also gave us a little guidance on that limited scope representation. And as I talked about before, it requires that the limited scope representation be clearly defined in a client-signed agreement. We'll talk about how they understand that, but I put in a sample limited scope representation agreement, something that I just kind of threw together. And when I first, I'll say back in 2007, started looking at the limited scope, I took a very hard line. I was just like, well, I'm just not going to do it. I think this is fraught with, difficulties. I'm just not going to do it. But I think the fact of the matter is that, as I said, even sophisticated clients have very discrete circumstances under which they want your service, and sometimes even very discrete limited scope representation is better than no representation. And so I kind of got off my high horse and decided I was going to try to figure out when it's appropriate, how to do it, and how to do it safely. So I threw together this sample limited scope representation, and I think that whether you use this or something else that you devise, this is really critical. If it's a limited scope representation, the hardest part is you're most likely going to get that call and your brain is going to start running on what it is you need to do. If that closing is literally 24 or 48 hours away, the idea that you would sit down and draft an engagement letter to describe what it is you've been asked to do doesn't quite make sense. You've got a lot to do in a very short period of time. So I think the key is that you've got to have in your arsenal a template or something that you can use really quickly. Because if you start doing the representation and you haven't documented it, as the Supreme Court rule says, I think you're opening yourself not only to a potential malpractice claim, but potentially a rule violation.
Can I ask a question?
Sure.
I'm not in private practice, so I know nothing about this.
That's okay.
Which is really nice. I
No, that's really good.
got out of private practice in 2007, just in time.
Just in time. Before.
So you have this form letter, but
Right.
you're going to be doing your closing 24 hours from now.
Right.
It's a digital age. Can
Right.
you do this via email such that the client can respond and say,
Yes.
I've identified this is the scope what I'm doing. Can you? So an email signature is sufficient.
Right. The Supreme Court rule requires that the consent be in writing, but they acknowledge the age in which we live. And so I've prepared this as a letter template, but it could be by email. They could reply by email, yes, I agree, yes, I understand. It could be an e-signature. It could be a signature that's scanned and faxed back to you or scanned and emailed back to you. But you do need writing that evidences that client's informed consent.
Michelle, even with all of that, when you get a client, potential client, who calls and says, I just want you to look over the paperwork and make sure everything's okay, which happens on a very routine basis. Everybody in here knows that line. How do you respond to that particular client, potential client?
Potential client. Honestly, this probably isn't the most logical way to say it, but when they say that, I suggest to them that in order to make sure that everything's okay for the closing, if that's what you're asking me to do, I need to start with the offer. The offer may say that there are credits or charges, or it says who's supposed to do what with respect to taxes, or any number of things. So if I'm looking at a closing statement and I haven't looked at the offer, I can't tell you whether that closing statement is correct, right? So I say to them, I'll need to look at the offer and any amendments. I'll need to look at title to see what that might say about, again, taxes, back taxes, assessments, those kinds of things. That affects the closing statement. And so I will need to look at all of those pieces in order to make sure that your closing statement accurately represents the transaction. And they'll say, well, no. the offer is fine, everything's satisfied, so I just need you to look at the closing statement, and then I will say to them, then there's no sense in paying me at my hourly rate because I can't do what you've asked me to do. I can't assure you that the closing statement accurately represents your transaction if I don't look at least those two pieces of information. So it's your call. You could pay me $250 if you'd like, but it's not going to get you anything.
That's pretty hard for lots of people to understand.
It is.
Yes.
It is.
Do you find yourself turning people away
Yes.
at that point?
Yes. Selfishly, that's not fun for me. I mean, I know I'm not really adding anything to the mix. If I'm looking at I can do the proration. I can see whether the numbers have been calculated properly, but that's not what they asked me to do. What they asked me to do was ensure that the transaction is properly reflected. If I don't look at those other documents, I can't do that. And so I will say to them, you could pay me $250, but you're not getting what you asked for. I'm not, in the habit of doing things just for the $250.
Mark, have you turned people away, or how do you handle this?
I have turned people away. I have turned people away sometimes when they've called in that way. Again, it depends on how quickly the closing is approaching. One avenue I've taken sometimes is, well, you'll have to come in with those documents so I can go over them with you. That will slow them down too. And because I always say they don't really want the advice, they just want to borrow my malpractice insurance. And so I like to go through.
And neither a borrower or lender be.
That's right. Because they don't understand. So there's a lot of education at that point, of just educating the clients as far as what the potential risks are, and that I can't really assess those without seeing everything and hearing the background on what's been happening in the transaction. Because you're so right that there's a reason when they call you just before the closing. Something's going on. And I do factor that into the fee I quote, because this is not a simple matter where at that point there's something lurking out there. And
I'm curious, do the new ethics rules make this limited scope representation harder or easier for a lawyer? What do you think, Michelle?
Well, I'm not sure that you can put the blanket on it. In the new rule, it talks about reasonableness under the circumstances, and it talks about what the lawyer needs to do to be able to discern whether it's reasonable under the circumstances. You have to ask questions. You have to get the facts and circumstances. And so, like Mark, when you start delving into that, it feels very much like the way you would begin any other representation. And it seems to me that you're doing a goodly amount of work for what is supposed to be a very limited scope representation. And so in that regard, I think it's a little bit harder, because you're trying to make this assessment about whether this particular situation is appropriate for limited scope. You would then have to explain to the client the benefits and detriments of doing it in limited scope. And again, if you just agree to the representation, you may talk about what the scope of your representation will be and on the various steps, but you're not in that, I'll call it sales mode, kind of either telling them all the terrible, horrible things that are going to happen if they don't have representation, or conversely selling the benefits of having you represent them in that transaction. So in that regard, I think it's a little bit harder, because in order to satisfy this, you have to make these assessments, you have to have these conversations, and ultimately make the determination.
Yeah, and I think that is, in the end, that's the big deal. Is now we have these representations. We've got clients that we have to try and make understand what's going on, and you're always doing it on not just a limited time frame, but a very, very limited time frame.
Right.
So
I go back, a couple other quick points. I go back to this. Again, in that really quick time frame, if you don't have something ready to go, I guarantee you are going to shift into problem-solving mode, and you're going to be in the middle of this before you've actually gotten that written consent. So whether it's this or something you've drafted or a standard email, make sure that you have something on tap ready to go. And then, second piece, as kind of Mark alluded to, I think you really have to be prepared. If you send this to the client, or if you send the email to the client, and I say to them, I'm going to send you this, and I realize we're on a very short time frame, but you're going to have to open this, read this, and I need this back before I begin to assist you. If you jump in before you get that, I'll tell you, A, you may not get it back, and B, you may have discovered something else that tells you that this really isn't appropriate for a limited scope, and now you're up to your eyeballs, having quoted them some fairly modest fee to do some very limited scope item. So you, I think, have to be prepared to send it, require that they read it and sign it, and get it back to you before you actually pick up the pen and start doing work.
Okay.
There was a question up front?
Yeah, we got it.
Yep.
I understand the limited scope and the template that you've got, and I think that's great. What happens in this kind of scenario, at least in my experience, is, okay, you ask for all the documents that you need. Well, amongst those documents is the title commitment, and in reality, amongst the documents that you want to look at are all the exceptions that typically depends upon the title company aren't necessarily provided right away. And so you need to look at those.
Right.
In my mind, as an attorney, it's not reasonable representation to not look at those, because those might be the biggest problems.
Right.
And so in limited scope, it's almost like, well, we'll do it in limited time, but we'll do everything, and then and then we're hopefully gathering everything and getting it back in time. And so in looking at what you've got on your template, do you also identify explicitly what you will not be providing?
Right. Now, I will say, I would like to say I'm extremely persuasive, but I do have exactly that conversation, and I have to say, it's not the numbers on the closing statement that are going to present an issue for you. It might be title, it might be easements, it might be all of these other things. And so, your option is, I can look at this very limited thing, and then I'm going to send you a letter that says what I am not looking at and what I am not assisting you with. But you might want to think about that. And generally speaking, they do understand the nature of what I'm explaining, and they ultimately decide that they want, which is maybe the worst of all worlds, full representation in limited time.
At a limited fee.
Well, yeah. But you do have that discussion. And I think, as Mark alluded to, and I think you as the lawyer have to ultimately make the decision of whether you can or cannot competent, and we didn't really have time to go into it, but the Supreme Court rule says limited scope does not mean limited competence. You still have all of the competence obligations there. And so you don't get to say, gee, you only gave me 24 hours, so I gave you kind of close enough. And the Supreme Court rule makes it very clear that you cannot prospectively limit your malpractice obligation or your rule compliance obligation. So you can't in your template say, oh, and by the way, because you did this, you asked me to do this in really super quick time, you hereby waive any malpractice claim that you might have against me. You can't do that.
Yeah.
Don't do that. You really shouldn't do that in any, that is in the rules. But in the limited scope, you can't specifically say, in light of the limited scope or in light of the limited time, I am also limiting my liability to you.
We had at a convention many years ago, 2 young lawyers come to the WILMIC booth to talk to us, and they said, we're just out of law school and we're just getting started, so we're marketing to our clients by saying, we're brand new, we don't really know all that much about what we're doing.
That's a great selling point. Yeah.
But we're going to spend a lot of time on you, and you're going to be really important to us. Do you think that's a good marketing plan? Well, and we're going to be cheap, was the other thing. So we won't charge you a lot, we'll care about you a lot, we'll do the best we can, but we aren't going to make any promises here. That's kind of what this reminds me of at this point. This
So-
is a tough business.
It is. The last point I guess I'll make, because then I think I'm over my time. The Supreme Court rule does not require it, but I do this in my practice, and I would suggest to you, particularly in the limited scope, it may be a good practice that you would want to adopt. So you do the engagement letter or the email or whatever it is to document the limited scope on the front end. When you're done, unlike what you might do with other clients that you hope will be your clients for time immemorial, I send, along with the bill, a little closing letter that says, enclosed is your invoice for the limited scope representation, wherein I did bing, bing, bing. Thank you very much. It was a pleasure to assist you. Have a nice life. I mean, it is, I kind of do that for a couple of reasons, not the least of which is the point I made at the beginning. Because the nature of my practice otherwise is to do the full scope, if I have that letter on the front end of my file and World War III is about to break out, and I go, oh, this was limited scope. So that's why that's why there are not contingencies in here that I would normally do, or that's why X or Y. And then I flip to the back of my file, wherein I presumably have my signed acknowledgement of the limited scope for the client, and I go, okay, 1001, 1002, 1003, and I breathe a sigh of relief. Now, I fortunately have not been faced with some World War III, but that's what I'm bookending my file to say, here's the nature of our representation on the front end, and confirming to you again on the going out, here was the nature of our limited scope.
And I want to really stress that I don't see this as, yes, there's some CYA involved in all of this, but there's also client education involved in that. And I think it's really important for the client to understand what the client has purchased with those services that you render to them. Yes, go ahead.
Michelle,
Yeah, it's on.
am I on? Oh. I presume that you're also requiring that the fee be paid before you start, and that's the impetus to get this signed. And then, of course, at the end, and I guess 20:1.17 says you have to tell them that it was a flat fee arrangement, and they can now dispute your fee.
Well,
And you put that in your closing letter.
I actually don't do the payment up front, and I don't do it on a flat fee. I still do it. I will say, this is what I am being engaged to do for you. Here's, in my sample letter, it says, I think the fee will be between this and this. So I'll give them a range, depending on the time frame. Maybe it's a 2-hour, it's 1 to 2 hours to do something that they have asked me to do. And then I'm sending them a bill afterwards. And I've been very fortunate in that my bills have been paid.
Okay.
Michelle, do you think you can restrict the documents that you are going to review for the closing? For instance, could you restrict your representation to reviewing just the title?
The rule says that you have to the lawyer has an obligation to determine whether it's reasonable under the circumstances. And I think in a real estate transaction, it could be reasonable to focus on title. They may say, I can do the calculations of the real estate tax proration, or I can look at the loan documents. This is my 4th house. What I really want you to do is look and see whether there are easements or encroachments or those kinds of things. I think that you could, under the circumstances, limit your scope of representation to title review.
Okay. Good.
Michelle, are you still finding that most of your clients are calling you for the limited scope, or are those fewer than the instances where the buyer is actually contacting you right from the start? I mean, it seems to me with a lot of the self-help that I would think that at least nowadays especially, more of those calls would be for the limited scope purpose rather than for the, hey, I'm looking to buy this house, I'd like you to help me from start to finish.
It's really on either end of the spectrum. You get what I'm a belt and suspenders kind of girl. I mean, I tell people that all the time. You get the belt and suspenders people who say, 2 weeks from today, we're going in to talk to our lender to see if we can be pre-qualified, but we want to get a lawyer now. Great. to the, I call it DIY. So they, went online, or they, did something online, and they thought that they would be fine. They've all had friends who have done this on their own. And then, as Mark said, something catches their eye, or something makes them feel a little overwhelmed, and then you get that call. I am fortunate enough in my practice at the present moment that it's not centered on residential, so I don't see it perhaps quite as much, but when I get those calls, it is probably more frequent, I just need you to do, fill in the blank.
Famous last words. We've got one more question, and then we need to move on. Go ahead.
Well, we've dealt with it to some extent with the last two questions, but if a client calls you 2 days before the closing and your representation commences at that point, how can that really be defined as a limited scope representation? At that point, you're doing the most you can for the client under the circumstances that the client has presented.
Well, I say that it's still limited scope. You are stuck with the offer that might have been presented. You don't have the ability to counsel them on additional contingencies or whether or not there are cure rights. So in that regard, it is limited scope. But you are still going to advise them based on, what I see here. Here are your rights. You don't have the right to terminate this offer because you don't like X or Y. This is what you presented. These are the rights that flow from what you presented. So that's limited scope.
Okay. And that's a great lead-in to our next topic, which is contingencies.
Yep.
So we're going to shift gears a little bit and talk about contingencies in the offer to purchase. Mark?
Thank you, Sally. And yes, Sally was my teacher. I think she had graduated from college at the age of 12 then. And she has accomplished something amazing. She scares me more today than she did when I was in high school with what she talks
That's why I
about.
went to law school. I couldn't scare 7th and 8th graders, but I could scare lawyers.
Oh, I was a senior. Come on.
Yes,
let's
you were.
put
Yes, you were.
in the right category. I want to talk about various aspects of contingencies. One area in particular is with contracts which leave contingencies too wide open. And here we get into the realm of if it's too good to be true, it probably is. And I quote you from Corbin on contracts. Let's go right back to law school, where you can have a promise which is an illusion if there isn't a promise at all. And this is where they have such an open contingency that a party can get out of the contract at any time. I remember early in practice seeing contracts that are subject to inspection to buyer's satisfaction. What's that? I also enjoy the contracts which, if you have a powerful seller in particular, a developer, and so they've got their contract, and they'll build in things very much to their favor. I understand that, why they want to do that. But they'll include a clause saying, if you breach the contract, Mr. Buyer, you lose your earnest money. If we breach the contract, we'll give you your earnest money back. How is this, where's the mutuality in that? And I raise this because I have used the matter of illusion in a contract or an illusory contract to get my clients out of a contract, but more often to renegotiate a contract. And I'll tell the other side, you don't have a contract here. It's so wide open on your side, you can't enforce this contract. And I think that's the area of risk for us, that because if you can't enforce the contract, you may have made the contract too good for your client. And now the question is, what are you going to say to your client when the contract falls through? So you have to be careful of that. The reason it's falling through is, again, the basics of a contract with the offer and acceptance, and consideration is the big issue here. There's no consideration if you can back out of the contract, and there's no consequence to it. I look at it on two levels. One is the ethics. Should you set up a contract where your client can get out? You've built in a clause that would get them out, perhaps. As I said, it can be a problem for your client, the one you're working for, but is it ethical to do that to the other party? And could there be ethical claims? Now, I don't know. I haven't seen that brought out. Maybe you have.
I haven't seen that.
Yeah, I could see that being an argument. This lawyer was putting in clauses which could get his clients out of contracts, and he overdid it too much. I can see that being...
Mark, can I mention something on that point?
Yeah.
Have you ever had the opportunity to see the standard offer to purchase in our friends to the south in Illinois?
I've read it, but not for a long time now.
The standard offer to purchase in Illinois provides that buyer and seller sign the contract, but it's not a good contract until an attorney reviews that contract up to 10 days later. And the attorney can decide, we just don't think that's a good contract. And they can get out for whatever reason they seem fit,
No reason.
including
my mind.
that somebody else submitted an offer for $10,000 more. So I would suspect that that, to me, is a little bit unethical. But you know, a lot of governors are in jail in Illinois. So
Yeah, we have to bear in mind the source down there. Well, so I look at it from the two standpoints. First of all, are you developing a contract for your client? And then the ethical question about that. Another area where I see clauses put in to get clients out of a contract is on the interest rate, which is put into a contract. If the interest rates today are 4%, so you do a contract at 3.5. Now I've left an out for my client. Well, I don't know if that would fall into the realm of an illusory contract, because theoretically the rates could drop to 3.5, and I want to make it contingent upon that. Unlikely, but theoretically it's possible. I will go back and challenge the broker or the other attorney when I see a contract with a rate underneath it, or more likely what you see is a rate right at what they are today. They've been to see the lender yesterday. Here's the rate. The response I always like to give to them is, so you're saying if the rate goes up 1/8%, your client's not going to buy this house? And, oh, no, well, we've got some room. Okay, well, let's build some in here. I have always maintained that the rates should be about 0.5% where they are today. The client should be willing to go ahead, even if the rates have gone up a bit. The other one that I watch for is when the buyer presents a pre-approval letter, and the pre-approval letter is for buying a house with a mortgage exactly at what they have in their contract. And there again, my response, kind of smoke it out, is, I know we're a little worried about your buyer because he looks a little thin, because he can only afford a mortgage for that amount that he needs in the contract. And I know what the clients are thinking, well, we don't want to let them know we've got more money. Well, anyone is foolish to look at the contract and say, oh, they have more money, so we'll take advantage of them. They're going to pay what they're going to pay. But to rely upon that they have more money so we can really hit them hard, I think is short-sighted on that. And on the seller side, I'd like to see they've got more. I would much prefer to see a client or a buyer comes in with a pre-approval for $100,000 more than what's in the contract. That's great. They're a real solid buyer at that point.
I've got a question for you, Mark. So, like you, I feel very strongly about the exceedingly low interest rate or time periods, et cetera. But flipping over to the commercial side, now, if it is two commercial folks, I'll call them equal parties, I get something that I've used this hundreds of times. Everybody understands, and they are both, sophisticated commercial. And it essentially says, give me all your documents to review, I need some financing, and I'm going to do some digging around the property. But it is not much more, yes, there's probably 4 pages worth of contingencies, but every one is, by my strict reading, probably illusory. Do you feel differently if it is a commercial transaction versus a residential?
I do, because you have the clients who have been advised of what the risk is on that. And so, no, I don't worry too much if it's commercial, if they're both sophisticated on both sides, and if they're represented by counsel, which you usually have in commercial transactions. So it's a little bit hard for the other side to say, well, we didn't understand that this was an illusory contract. I said, well, you were represented. You've been in dozens of transactions before in the commercial context. Kind of hard for you to argue that you didn't realize it. So I think you do have that option there in those cases. So I just like it because it can reopen the transaction for negotiation. If you see that there is such a clause in there, you can jump on that to renegotiate the contract, which I have done a number of times over the years. If it's bad enough, okay, we have an illusory contract. My client is still interested in the property, but let's talk about the terms here in the contract. Be aware with financing on the property, and I give you the citation to the Perkins case from 1980, which nicely laid out the components of an acceptable financing contingency. We look and say, well, it's got to have the interest rate, it's got to have the amount. They went on beyond that. Amortization, is it fixed? Is it adjustable? Are there points being paid? So be familiar with what those requirements are. It's built into the clause in the contract, in the offer to purchase. Where I see a problem with that is on the second mortgage contingency. I so often will see contracts, especially the broker-prepared contract, and subject to the buyer getting a second mortgage for $150,000. That's illusory. What are the terms of that second mortgage? And we want to nail it down, because otherwise, first of all, the buyer may say, well, I was hoping to get X percentage, and I couldn't get that, so I'm not going ahead. I couldn't get the financing I wanted. So you need to do that, to put that contingency in. I've reviewed some contracts for buyers where the contract's been prepared by a broker and they have a wide open contingency for the second mortgage. And I will go back into it and we'll amend it to put in what the contingency, what the specific terms are. Sometimes I've had clients who have, we have a buyer who said, well, the lender rejected my loan application. I always ask for a letter from that lender. Give me something proving that they did that. I remember having one years ago where they had gone to the lender who was the buddy of the buyer, and they said, well, they didn't approve my loan. And so, okay, well, bring me a letter from the lender. It was real interesting. We couldn't get that letter from the lender because the lender was fine saying, tell them your loan wasn't approved. Another thing, when they have to put their signature on that document saying you're not approved. And they hesitated on that. They didn't want, and we eventually found out that no, they could have gotten the loan. And we worked it out. And I can't remember how, but we worked it out. The question arises sometimes whether the buyer can waive their financing contingency. And that's a challenging question because there's nothing in the contract saying they can. Sometimes I've added that in contracts, but I'm not so sure the buyer has the right to just waive their financing contingency because they've built it in there. This is part of their terms. When I have, because you're essentially saying, oh, it's a cash transaction now. Well, when we have a cash transaction from the beginning, I want to see that they have the funds that are available, that they have the funds in the bank, there's a path to them getting those funds. And now if we have a contingency and they waive the contingency, I know they need a mortgage. Are they going to be able to complete the transaction? So I'm actually a little more concerned with cash transactions than I am with the contingency transactions, because a lot of times people will fill themselves up that they have no problem getting this financing, and then they have to get it. I always remember reading a comment in the ABA Journal years ago with transaction and a buyer. A woman said, well, I'm expecting funds to come in. It was cash transaction, and then it didn't happen, and it didn't happen. And finally, and they kept on giving extensions, finally the lawyer for the seller says, can you come in and bring in the material showing you got the funds? And she did. She came into the office, and they asked her to present it. She pulls out the envelope with Ed McMahon's picture on it.
No.
She has the funds.
I thought you were going to say a lottery ticket.
No, Ed McMahon. Well, that would be just as bad,
Yeah.
I think, too. So you need to know, and that's why that happens in those cash transactions. Inspections can bring their own issues as well. I always am very attentive to the timing on that because I think it's confusing for buyers. We all know you look to see that 10 days to inspect. It's not 10 days to inspect, it's 10 days to deliver that notice of defects. And that's the key, to keep that in mind. That should be your focus. I find so many clients think that they have that 10 days to inspect, and they'll ask me, now how much time do I have to deliver the notice to the seller? So I go over that. That's in my engagement letter with them about the timing. The other thing I've run into with clients move here from the East Coast, East Coast counts pretty much from business days, and with the weekdays and holidays out of there. So they come in, if they see 10 days, they're not counting the weekends. So I want to make sure they understand that's how it goes. If you have, then you get the question of, well, is it a defect with what they've presented? About the only thing we have to go on in Wisconsin in law is, I go to the administrative code has a definition for home inspectors on defects. The other thing I've gone to in the Milwaukee area here is the Metropolitan Builders Association has the standards, construction standards for Wisconsin, so for this area. So sometimes you can hang your hat on that there is some reference to it. And watching to see, is it timely when they delivered their notice? And bearing in mind what you have to have in that notice, it has to be a copy of the inspection report, it has to be their notice from them, and the notice has to say specifically what's objected to in that report. They can, and a lot of times they think they can just send the report and say, here, I'm canceling based on this report. So you got to have more than that. You've got to have the specifics of what it's about. Now, if you're in the seller and you just assume get rid of these buyers, go ahead, then you let them go. Watch the delivery options. Whenever I'm giving notices under the contract, first place I go to is back on page 1. How do we deliver this notice? And I think that's something at the start of transactions we tend to go over, and yeah, it's in there, but you've got to follow that. Now, I may do it a couple of ways. So if we have an address for the buyers and we're giving a notice as a seller that they have not fulfilled their obligations, if we have the address, I may send it to them. But if the contract says the notices go to the broker, I'm sending it to the broker. That's the important one. Because otherwise, you have not followed the contract obligations. You have to give the notice, and here's the delivery method for giving that notice to the other party. Clients are confused sometimes with whether or not how code comes into play here. If a condition does not meet code, they think that's a defect. And I'm not so sure that it is. In fact, I don't think it is. It's the condition of the house may be okay, but the local code says it's not up to the code standards. But when you look at the definition of a defect in the contract, it doesn't talk about code. It talks about the condition, the expected life of the property or its components, health and safety, the effect on the value. These are not code-related items. So I think you have to be careful. Now, if something isn't up to code, that may support the argument that it's not solid, it's not structurally sound, but it's not. It doesn't answer all of it. The other thing that I look at is if it's the timing in the contract, and the timing for, people get excited about, well, is it 10 days or 20 days? I'm very excited about that. I want it short on the seller side. The other thing people get excited about, especially sellers, do you have the right to cure? And I've had so many sellers insist on having the right to cure. Frankly, on the seller side, I don't care. I don't care. As long as the inspection period is relatively short, if it's 10 days, if this buyer doesn't want the property, let them go at this point. It's early in the transaction. That buyer is not worth hanging on to because there are going to be problems all the way along. They'll be looking for other reasons to get out of the contract. So I don't get too excited about that. Now, on the flip side, if I'm representing the buyer, I really don't want that seller to have the right to cure. Because I don't know the nature of the cure that they're going to have. And some of them are real easy because it's very clear what has to be done. But some of them, if I were the buyer, I'd say, I don't think you can really adequately deal with that problem. I'm not willing to take the risk on that. That problem may take several attempts before it's addressed and corrected. And so I don't want to leave that open. If I get a lot of pushback from a seller on that, I will come back and say, all right, we'll give you the right to cure, but you have to tell us what your proposed cure is, and we would have the right to reject that cure. I think I put them back in the position I would want them in without the right to cure with that. But at least it gives us something we can hang our hat on, because otherwise there isn't much we can do. You had a question. Did you, and wait for the microphone. We've got it coming.
It's more a comment.
Okay.
But, you know, like in New Berlin, for instance, you have to have an occupancy permit for residential, okay?
Right.
So naturally, if I represented any buyer that's going to buy a house in New Berlin or Shorewood or some community that actually enforces their codes, you would put that in that you must be able to get an occupancy permit. So if there is code violations, that would take care of it.
That would, yes, that will take care of it. Now, and I agree with you on that. That would address that. Be aware there was a new statute last summer that prohibits communities from requiring a code compliance certificate to transfer a property. So, yeah, New Berlin, I think it was just in July or so. It's pretty recent.
Yes.
So, did I hit that? Did I hit it
You
right?
were perfect.
I had a 1 in 12 shot on it. So that's going to knock out a lot of that. But that also it caused me a little bit of concern, because I've had a lot of clients who've relied upon that. Well, the community has inspected this property. You know, I never, in a sense, you weren't as concerned about New Berlin or Shorewood, any of the communities that had their inspections and required their certificate. I question that, though, because most buyers today get a home inspector. So, and I would rely more on my home inspector than the inspector from the community, because they're just looking for code issues on that. But no, you're right. That would cover it. We may go back to that. You know, this is just, with this legislature this year did that. I don't know if that will last or not. I'm always cautious about delivering that notice of defects, especially because in my contracts, if I can get it in, the seller does not have a right to cure. If you do not give the seller the right to cure, and you give that notice of defects, the contract is null and void. By its terms, it's done. Now, in most transactions, the buyer doesn't want to walk away from the transaction. They just want the seller to take care of some things. If you give that notice of defects, the deal's off. Now, you don't know if that seller is just waiting for that. And I've had those transactions where they've got another buyer who's waiting in the wings, a better buyer, a higher price, and what can we do? I said, well, let's wait until the buyers have their inspection, because they didn't give you a right to cure. So they send in their notice of defects, and out goes our notice saying, no, we're not going to repair. Here's the cancellation agreement. Thank you very much. So you have to be careful about delivering those notices. So if I have that, because I usually don't give that right to cure, it's just a question of how you handle it. You don't send out that notice of defects. You raise the things. If there's an attorney involved or a broker, you talk to them about it. You may send an email with some of your objections, what you'd like them to take care of. But I'm just cautious about that. And then the other thing is, I always keep an eye on that deadline, because once we're past the deadline, there is no incentive for that seller to do a thing on that property. So you've got to catch it while the iron is hot, while they're trying to hang on to it. And even if your client is saying, oh, I'd go ahead and buy it anyways, but I just want to get them to take care of it. Okay, then especially you do not want to give them that notice of defects. You let them know what your objections are.
What a lot of the real estate agents you see now, what real estate agents will do is they'll submit an amendment to the contract in lieu of a notice of defect, because it is, an amendment is not a notice of defect. But to your point as well, though, you always have to be cognizant of that. 10-day, 15-day deadline to supply that notice of defect, otherwise you've blown the deadline.
Very good point.
I was going to say, and I've seen many instances where that amendment comes across on day 9, and then interestingly enough, the broker has given them like 24 or 48 hours to respond to the amendment. And while that's pending, they'll ask me some question. I'm like, would you buy the house or not?
Right.
And if you would not, then by this time tomorrow, we have to give notice, otherwise your option to get out is gone.
And an amendment does not obligate the seller to do anything.
That- and right,
All you're
exactly.
doing is submitting it, and if the
Right.
seller is sitting there holding on to it, I mean, the
No,
time is
right. The
ticking.
time is ticking,
so
and you
you've
could
got to
get
have
past.
that notice of defect in your hip
Yeah,
pocket if
that's
you
right.
expect you're going to, if you're willing to
Exactly.
use it.
That's right.
Good point. Yeah, you have to watch that. But I also, in those circumstances, and we've got 1 day left, I'll do an amendment to extend the
Extend.
time. Extend it 2, 3, 4 days, so that I also tell the clients, this way we don't have a gun to our head on the negotiations. Yes.
Mark, you're right up next to my question. You've almost answered it. But assuming that in a non-brokered transaction, you're representing the buyer, you're negotiating for a cure, you've maybe proposed an amendment, but you're waiting on the seller. As a practical matter, considering that midnight of day 10 may fall on Saturday or Sunday night, how do you, as a practitioner, do you preload your client with a notice that you count on them to deliver? What do you do as a practical matter?
I do, preloading that really captures
that
the
word.
idea. Yeah, I do too. I'm going to use that more
use that
often. No, that's what I do. I have given clients an amendment, and then I'll also give them a notice of defects. And say, okay, and if it's coming up on a Saturday or a Sunday or a holiday, here's what you need to do. You need to decide. If you do not want to buy this house, and we have not heard from those sellers, you're going to have to decide at that point. And either you accept it the way it is, or send off the notice of defects to them. You have to, because so that the client understands what they're doing. And what I like is I cover my bases with that, which Sally will like to hear, that because I've sent them an email with that notice. So, and in that email, I tell them what they need to do. Here's your situation. And so it's covered, they're informed, they know what they're doing with it then too.
And there's a record of it, which is even better.
Yeah.
I sometimes will use the little delayed delivery on Outlook. So I will have it ready to send, so I don't have to go run to my office, because right at that moment, the client will say, oh, my computer was down, or I can't scan it and sign it, or what. You're thinking, really? So I will have it preloaded, and both will be signed, scanned, attached, ready to go, with delivery at 11:50 on the critical day. I can always run back into my office if and undo it, but then I don't have to worry about rescanning, et cetera. That actually came in handy once. Yeah.
Could you just-
I don't do it all the time.
Couldn't you just submit the notice of defect and the amendment at the same time and say something along the lines that the notice of defect is deemed voided in the event that the amendment is accepted by X date at X time?
I'm
Again, I'm not in private practice, so.
Aren't you glad?
I think because of what Mark mentioned, I'm always really leery. Once you give that notice, if there isn't that right to cure, I'm always worried that the seller has another potential buyer. And I don't want them in any way, shape, or form to say, I didn't get this, or I didn't get that, and take the easy exit.
Yeah,
So I only give that notice if I really, really, really mean we're not going forward.
Yeah, I would agree on that. The last thing I have is, how do we deal with issues if there has to be some sort of an adjustment in the transaction? You've had the defect raised, seller wants to address it. How do we address that in the transaction? Again, coming back to my illusory contract question, because do we just give a dollar credit? First of all, lenders have really restricted us on what we can do. Pretty much down to just price reduction. That's about it. Because escrows really doesn't work. Maybe if you have a weather-related repair, you might be able to do that. but otherwise, they will not let you push it off to a later date. You've got to address it now. So there's going to be some sort of a financial adjustment with the buyer, which creates the problem then within the contract. If you just give the credit to the buyer, I haven't had this happen, but I always worry about that, a transaction in which a seller has given a buyer, we've reduced the price. And with a buyer, with a sharp lawyer coming back and saying, where was the consideration for me as the seller for that price reduction, especially if the lawyer wasn't involved but a broker did it, and say there was no consideration for that price reduction. And now you're too late to do anything about it. So I always like to put in something in there that I can hang my hat on, and I've given you an idea of what you could do on page 7 of my outline. I'll reference the fact that we're within our period still for cancellation and giving a notice of defects, and so I'll say price has been reduced, and then the second part of that is, and the seller and the buyer acknowledges they have completed their inspections of the property and waive their right to deliver a notice of defects. Okay, now we've given some consideration. We've waived that right. They've given us a price reduction. And the best part is the lender doesn't have to know why did we drop the price. And the lender doesn't have to know, but they all know why that price reduction was there. So, but they don't want to see it. That's how I've dealt with that, just to address that price reduction. How do we do it otherwise? I think it's my time.
I'm going to give you about 4 more minutes here.
Okay. Well and septic inspections, I guess one of the key things there on the well is when I started in practice, it was bacteriological contamination, and that was it. You looked to see if there's contamination, and you chlorinated if there was. Then came nitrates, putting in nitrates arising from the fertilizers. In the city, but probably a bigger problem in rural areas, but in the cities, everyone's fertilizing their lawns, and if they've got wells in the area, it's a risk there too. Of late, I see arsenic all the time. Now, my understanding, and I have a limited understanding, I stayed away from the science side of the campus when I was in college, but my understanding is that you have to put in, I don't think it's reverse osmosis, is that, no, it's?
Ferrous, iron.
Iron,
Iron
okay.
attracts the arsenic and then drops it.
Okay, so an iron filter then, is that, or,
No,
I don't.
I had a mobile home park, and they had high levels of arsenic.
Oh.
Oh.
It's too good to miss.
Somebody who knows science.
I had a mobile home park, let's say somewhere in Wisconsin, and first it was nitrates were too high. So they go and they dig another well to find out that well has arsenic in excess of EPA standards. So they had to build a plant, small plant, and basically they drop in ferrous oxide, just iron, precipitates it out, and they have to flush 5,000 gallons a day every day out into a pond in order to, clear the system. So, it's a big problem if you have arsenic.
It is, and I'm finding for my clients, I've had some clients buying single-family homes, and the arsenic level is high. And the cost is thousands. I mean, the last one I had, they said 10,000 that it was going to cost them.
Oh, my gosh.
Plus the maintenance on that. So it's a big cost. But I like having arsenic around, though, when someone says, well, it's all natural product. And I say, well, so is arsenic.
The problem is then you have to get rid of the arsenic.
Yeah.
Okay, and so that has to go to a licensed facility.
It is a problem, so I don't, well, those are the factors today, but who knows what we're going to have later. So the other issues with radon, I don't see as that much of an issue in transactions. I mean, it's in every contract, it seems, but your cure is about $1,000 to take care of it. So it's quantifiable.
Okay, that's good. Tom, we got something from the internet?
Yeah, we have a question from the web. For the well issue, does this apply to private wells or community? What happens if the seller tests his well years before selling?
Well, I think if he's tested the well years before selling, I would be concerned as a buyer that is it still a valid report on that well? It could be, your mention of the arsenic, it wasn't there, but then they drilled a new well, presumably right in the same area. Now there's arsenic, so with arsenic coming in, that could be an issue. Community wells, I was thinking private wells on addressing this, but community wells are, I think they tend to be regulated and they're reviewed quite a bit. I've had some where it's been an issue with a community well, and frankly, I'm not sure of a good way to handle that because the client doesn't have a whole lot of pull over what could be done on their community well. And sometimes these are in a small group that there's a limit to what you can do as an individual, so because it's the group that's making the decisions on that.
That may also implicate some property disclosure rules. So if they previously tested that, interestingly enough, what did they put on their condition report?
Yes.
And that's an interesting question, too. I was talking with lawyers not terribly long ago about condition reports, and I'm curious about what this group thinks about it. Because often if you go to an open house, there'll be a condition report with the materials that the broker has out on the counter in the kitchen for the client to, or the prospective buyer to pick up and look at and review. Is it a problem to give a condition report before an offer is made?
One thing it does is it eliminates that as a basis for walking away from terminating the contract. Your scenario of the condition report out on the counter in the open house raises the question of which condition report did the buyer get if the seller has updated that report and they've amended it. So, and then I think it's important when you look at the contract, and there is the reference to condition report dated, and is it the same date as our latest one?
And the problem that the lawyer that I was speaking with had with that was that they thought if it was presented prior to the contract, then it was, it implicated the consumer statutes making a misrepresentation to induce the purchase.
It's also interesting, if you look in the inspection contingency, if there are things that are disclosed in your condition report, then you have an issue because there is knowledge as to whether you can in fact identify those as defects. When you look at the language, it tells you there's an exception for those items that were disclosed in the condition report. So you see stuff, or it's disclosed on the condition report that there was some roof issue. You then have your inspection, which in your mind quantifies the problem, but theoretically, if it's already disclosed on the condition report and you could easily identify it, you may not be able to identify it as a defect in the for the contingency.
One other thing, when you mentioned the consumer statutes as well, if those consumer statutes apply to the real estate condition report, the question also becomes, does it apply to if somebody just submits a drawing and say, or we updated the roof, we replaced the roof, we updated the furnace, air conditioning's brand new, these are the room dimensions.
Right.
And do those consumer statutes then apply as well when you're even kind of giving dimensions of rooms, unless you put a big disclaimer saying that these dimensions are really nothing more than estimates?
And that the pre-printed form does essentially say that with respect to like acreage.
Okay.
Yeah.
Okay, good. Now, I promised, we got another question? Okay, one more, and then I've got one more issue up here. Go ahead.
Just from a broker perspective, I wanted to mention that the prevalence of the real estate condition reports on the kitchen counter relates to the fact that the brokers have their own duties of inquiry of the sellers with respect to defects, and the brokers are required to ask that the seller's response be in writing. They are not required to compel the seller somehow, to give a real estate condition report, but the condition report is essentially the broker's
Satisfies.
proof that it has complied with its duties
Yep.
under 452 and
Yep.
Chapter 24.
Interesting. Okay, one more question?
And I think as a practical matter,
Okay,
hang
we
on.
got to get you on, there are people on the web who want to hear you.
As a practical matter, buyers are looking at the condition report before they see the property because the condition reports are widely available on the multiple listing service.
It's true.
Yep.
They're out
That's a
there.
good point.
Okay. Well, one of the things that I told this group of people was that I'm going to pretend to be their client for a minute here, and I'm going to ask them to help me just draft a deed and see what kinds of considerations, what goes on in these people's brains when your client says, just draft me a deed. Okay.
Have you asked the question?
I've asked the question.
Okay.
Go ahead, fire away.
One scenario that I see working in the title industry is you'll have a parent conveying to a child or parents conveying to a child and saying this is a gift. Or we run into scenarios where the lenders will send us a request for a deed when mom is conveying to the child. And the question becomes, at least the idea or the general rule is, well, it's an exempt transfer. It's not subject to the transfer fee. That's where a lot of the questions come in. It's not subject to fee because it's a gift from parent to child. Well, if the actual exemption says that it's a gift, as long as it's a true gift, it's nominal or no consideration. Well, think of the scenario where a parent is, or a son is borrowing money, okay, in connection with the conveyance, and there's an existing bank loan on title. So Sonny Boy is going to pay off mom's mortgage and then basically be the titled owner to the property. And although Sonny Boy is not actually buying the property from mom, they're actually giving some sort of consideration by eliminating mom's mortgage debt. And that tends to be, at least from a lender standpoint, a lot of times a surprise, because many times they'll think this is an exempt transfer because it's from parent to child. Sometimes where it'll pop up with the Department of Revenue taking a peek at that transfer return and seeing, even though the box gift may have been checked, they look down and see what type of financing was involved. And if they see that there was conventional financing involved, they're going to raise the red flag and at least start inquiring and saying, wait a minute, if there was a bank loan involved, where'd the money go? What was the money used for? Well, the money was used to pay off mom's existing bank debt. Well, then it's no longer an exempt transfer. You owe the transfer fee, plus you owe penalty and interest. And sometimes this can come years later.
Yeah.
I remember when they did that in transfers between husbands and wives, until the Department of Revenue included an exception for that. And so there were a number of transactions where there was a refinance, one of the spouses owned the property before, now they're going to add that spouse to the property. Well, you have the consideration in a mortgage. That was the argument from the Department of Revenue, that you had put a new mortgage on the property, so the spouse is taking that on, that obligation on, or at least part of it. And so, yeah, they were hitting the transactions with transfer. That's gone now. So
Yeah, so as a practice pointer, if you're ever asked to prepare a deed like this, it may well be worth it to perhaps get a letter report from a title insurance company, at least to check and see, are there mortgages outstanding? Is there something out there that perhaps could indirectly give the Department of Revenue a reason to say, well, wait a minute, this is not an exempt transfer. There was consideration provided in connection with the conveyance.
Okay, go ahead.
I'll tell you the things that I start asking. I had a commercial client this summer that did 11 separate sale leasebacks. And they marched into my office with files from when they purchased all of these 11 properties. And this was great. I had title insurance. I had all this documentation. This was great. Now, these were commercial sales, et cetera, and we were ordering title. But in 9 of the 11 instances, Department of Transportation had been through There were new roundabouts, all sorts of things, little pieces of land that had been carved off for redevelopment of roadways. And so step number one, particularly in that limited scope, we just need you to prepare a deed. And they give you the documentation, or they give you the prior title, and this should really only take you 15 minutes. And what you find is that the legal description is not at all what it used to be. Now, in my situation with commercial, yes, we had new title. But frequently, if it's the parent-child or family members, nobody is interested in paying for either outright title insurance or even a letter report, and now your fingers are the last ones that are on that transaction, and you have now clouded title. And if I were going to cloud title, one of the few people that I really wouldn't want to cloud title to would be the Department of Transportation, now having reconveyed land that they don't own. The other one that I get, and in my practice I do real estate and estate planning, and so I often will get the request, grandma wants to transfer the property. She has her eyes on the fact that she thinks she's going to need a nursing home in the not too distant future. And of course, they don't want the government to get their house. So that's issue number one. And they're also concerned about the length and expense of probate, and somebody told them that they could just transfer this now, and that will take care of everything. It'll be able, then they can just do a termination of joint interest, et cetera, and so they'll put somebody else on the deed with them. And those are really hard, particularly with family members, because some of these issues, I mean, first of all, you've got both sides standing in front of you, and you can explain the nature of individual representation till the cows come home, but they don't believe they need separate representation. They're not adverse. We are not adverse. We are not adverse. I told you that.
We're a family.
We're a family. Damn it. Yeah. So, I mean, you say all the things that you're supposed to say, and they're looking at you, and by gummit, nobody wants to leave the room. They're gonna explain it to grandma. So you're just gonna sign right here. And so you've got any number of issues and questions about the nature of your representation, whether it's limited scope or full scope, and whether this makes sense, whether even if you do this conveyance, it's something that could be called back into grandma's estate. I don't do Medicaid planning, but I know enough about it to know that I'm not going to assist somebody. It's not going to. It's not.
That's their goal.
If I know that's their goal, yeah. I know that I don't know enough to make sure that it's effective or that I've done it in the right way, and so I will certainly give them the names of others who know how to do that planning. But the call comes in, and it's real estate.
It's real estate.
It involves real estate,
Right.
and you're a real estate lawyer,
Right.
and so you should be able to help us with this.
Okay. Mark, any thoughts from you here?
Yeah, I have one, and maybe it's I'm overthinking this issue, but when I have a husband and wife selling a property, and one of them is on title, it had been purchased before they were married. Now we're giving a warranty deed. I don't like to have the spouse who is not on title originally warrant that property, the title to that property. So, and you see the deeds prepared all the time. John and Mary Smith, husband and wife, as the grantors. I will have the grantors, both of their names up there, and then I'll have a statement below that John Smith joins in this deed solely to
Release
convey his homestead or marital interest in the property. So I limit it down that he's not, and he does not warrant the title to this property. The warranty has to come from the one who took title to that property.
Okay,
Can I just add one thing?
Yes, absolutely.
We've been talking about it from a grantor's perspective. If I can switch it to the grantee's perspective, mom and dad want to convey to their child, their son, let's say, and their son's married, and they say, just give the property to my son. Gift, don't worry about it, do transfer return, there's no transfer fee, this is a true outright gift. Who's your client then, and how do the grantees want to take title? Are they taking a survivorship marital property? What's supposed to happen to that property when, let's say, the son dies before the wife? Is the wife who is the daughter-in-law, supposed to take that property. So I think you have a risk that you have dual representations there as to what the intent of the parents is vis-a-vis their son and their daughter-in-law.
You know, here's the biggest point that I want to make in that any deed that any lawyer does, regardless of what the client is asking you to do, is estate planning too. And I think so many real estate lawyers don't look at it from that perspective, and that generally means there are more questions to ask. There are goals to figure out. You know, when do you do a POD? When do you do a life estate? What does that make sense anymore? You know, and those are questions I guess I'd really like people to be thinking about. It's time for a break. We're going to give you 15 minutes. That on my watch says that we're back here just a little before 1:45. If that makes sense to everybody, please do that. Ask whatever questions you need and take a little time. Thank you.
Oh, thank you.
Thank you.
I was going to say.
we're back. For the second part of this program this morning, we're going to have Scott and Cheri talk to us about TRID, a whole new slew of letters, I guess, another acronym, which real estate is pretty good at. But this is one of those lovely little laws that is going to change life for everyone. In fact, it has changed life for everyone. So I'm going to just turn this over. If there are questions, please feel free to ask those questions, and we're going to let Scott and Cheri tell us what life is like in the title business with this new law.
Actually, we're going to start quickly. Before we got live here, we started talking about what's some new things that are going on in our industry as far as settlements and title. And a scary thing that's going on that I'm hoping you're aware of is wire fraud problems that the title industry and settlement industry is happening. Here's how the wire fraud goes. You're going to have a buy-sale transaction. Let's say I'm selling to Scott for $300,000, and I don't have a mortgage, so I'm going to get, $300,000 less a couple $1,000s in proceeds. I go to the closing. I say to my settlement agent, please give me a check for my $300,000 or so. Within a couple hours, the settlement agent receives an email, supposedly from me as the seller, that says, you know what, I don't want the check, I want the funds wired to this particular account. Settlement agent voids the check and wires the funds. So how many here think that the funds will actually come to me? No, they go somewhere overseas. This is rampant in our industry going on right now. My favorite one that I heard about is a place in Massachusetts where the settlement agent, in Massachusetts, attorneys are settlement agents. All settlement agents are attorneys. This particular attorney is a settlement agent, does a wire transfer of in excess of $500,000 domestically, but it ends up going overseas. But what this fraudster did is very cute, because basically the fraudster is sitting on somebody's computer waiting for the transaction, says, send money to me. Why should I steal money from you when I could just ask you for the money and you send it to me? This fraudster then sent emails to the seller and says, I'm sorry, I can't get you a check out because my daughter's very ill. She's suffering from cystic fibrosis, and we'll get the check out to you next week. And apparently those emails go for 3 to 5 days. And then finally the seller picks up the phone and calls over to the attorney's office. The attorney has been there the whole time, and his daughter is just fine, although the emails indicated that she passed away. And the reason the fraudster was doing that, so the fraudsters are really smart, sends the email to the attorney settlement agent, says send a wire transfer to somebody for an excess of $500,000, and then sends emails to the seller that says, sorry, I can't keep you the check. And the reason they were doing this, send the emails to the sellers, is to cause a delay because the money stayed domestically on the initial wire, it ended up being someplace in California, and then was shipped to Canada, and then from Canada overseas. And the fraudster needed to buy themselves time to be able to get those subsequent transfers going on. So, as I said, this is a rampant fraud that's going on right now. It's cost millions in our particular industry. Our company, to respond to that, has implemented a requirement that our closers do not wire money out unless we've independently verified the wire transfer instructions for the proceeds. And that independent verify is that we will pick up the phone, not in the email from the fraudster that says, here's my phone number. We pick up a phone to the realtor if we don't have the seller's phone number. Or we'll send an email to the realtor and say, give me the seller's phone number. We'll call and we'll verify those wire transfer instructions. Or at the closing, we will have the email with those wire transfer instructions and have the seller actually sign off and say, yep, I approve. These are my wire transfer instructions. And we don't have just one person when we send out wires. We don't just have 2 people when we send out wires. Typically, we have 3 people approve a wire transfer because we don't want to be one of the companies that's hit by this particular fraud. So to the extent that you ever deal with wire transfers and funds going out, please make sure you have at least 2 people authorized before the wire transfer goes out, and please always pick up the phone and verify the instructions. I think that's it.
I think those are pretty good tips here.
All right.
So has anyone seen or actually closed on the new closing disclosure form yet? If you haven't, I wouldn't be surprised, because I'm just now starting to see the closings using the closing disclosure middle to end of last week, and now they're going to be showing up a lot more frequently and then eventually the HUD-1 settlement statement is just going to be phased out. We're still seeing some HUD-1 settlement statement closings because of, and we'll get into this in a bit as to when this actual closing disclosure form came into effect, but as of right now, they're starting to roll in, and we're starting to see closings on these. So you'll start seeing them very soon if you start representing buyers or sellers. I think the way to do this would probably to talk about the new laws a little bit, talk about where it came from, look at the new forms, just show you what the, the kind of ins and outs or the differences between this and the HUD-1 settlement statement, and then perhaps just what's going to be more important to you as attorneys would be getting into the time frames and the requirements, especially if you're representing sellers, with respect to if you're going to continue to prepare your own closing statements and things, what your time requirements and obligations will be under the new rules.
So we're talking about the Know Before You Owe rules that came into effect. They started from the 2010 Dodd-Frank Act. Consumer Financial Protection Bureau is created out of that federal rules. And the CFPB, the Consumer Financial Protection Bureau, was concerned because coming out of the financial crisis, people indicated that, look, I bought a house and I had a $100,000 mortgage, but I didn't understand that after 5 years my interest rate would adjust, and I would go from, let's say, a teaser rate of 2% up to a rate of 7%, and which has caused my default. Or I didn't understand the implications that I had a balloon payment, or I didn't know there was a prepayment penalty. So the CFPB said, let's make the forms easier for consumers. I mean, consumer in yesterday's world would go to a closing, they would get a HUD-1 settlement statement. Boy, that's helpful. HUD-1 settlement statement. If I'm a buyer, I don't know what that means. Like I see, no. And then, it's 12 minutes, 15, 20 minutes into the closing. Finally, I'm getting to my promissory note. I'm now glossed over. My hand is cramped. So the CFPB said, let's make it easy. Let's give a 5-page form that lays out what your purchase price is, what your loan terms are, how long they last, what your interest rate is going to be, and what conceivably you need to pay in the foreseeable future buyer when you purchase a property. I have to say, we're going to go into the forms. The forms are great. They're very user-friendly. Then we're going to go into the rules. The rules are a little bit more difficult. The rules are going to make your closing. In September, people would write offers purchase and say, I could buy a house in 30 days. In today's world, it's about 45 days from offer to close because of the new rules. So let's go into them. Oh, here's our little disclaimer. Our disclaimer here is that we're attorneys, but you're attorneys too, so we're really not giving legal advice, right?
Right.
Right, yeah.
We never give legal advice.
Just quickly, Scott and I from Knightberry Title Group, we're a title insurance agency. Our company writes for about 5 different title underwriters, so we're not here as a title underwriter that makes risk decisions or claims decisions to the extent you have questions, but we are an agency that writes title insurance, and then we also do settlement statements and settlements of real estate transactions in Wisconsin and other states. So here's some quick info. You heard Sally talk about TRID. TRID is the word that we used to call it. It was TILA-RESPA Integrated Disclosure Act. The TILA is the Truth in Lending Act. That was when you would go to a closing, you would have a nice statement that would say, here's the truth of what you are buying, borrower, and this is what your loan terms are. And then you had the Real Estate Settlement Practices Act, which mandated the HUD-1 settlement statement. So there were two different government bodies that were fighting over each other, and they never integrated their forms. And in fact, they were supposed to integrate their forms in like the 90s. Finally, the CFPB said, yep, we're ready. Let's integrate those forms. Let's make it one nice, easy to read thing for the consumer when they're going to a purchase transaction. So that's what TRID is TILA-RESPA Integrated Disclosure. Comes out of the 2010 Dodd-Frank Act, as you saw. Started as of October 3 of 2015, we have these new forms. The key here is if the buyer-borrower goes into their lender on October 3 or later, they're under the new forms and new rules. So your date of your offer to purchase isn't the controlling factor. It is when they went to their lender. When they give their lender 6 pieces of information, then the lender has to issue what's now called a loan estimate. It used to be called a
Good faith estimate.
Good faith estimate. Now it's called a loan estimate. We're not going to go into the loan estimate itself, but you can just Google loan estimate. It's a 5-page form that really mirrors the look and feel of the new closing disclosure that we're going to go through. And the idea is that a consumer is going to get all the information up front under the loan estimate, and when they go to the closing, there's going to be no changes, no surprises. They're going to understand what they agreed to purchase, and in fact, what they are purchasing as a loan product. All right. As far as what it applies to basically your 1 to 4 family transactions. But it's a little different than what the HUD-1. HUD-1 settlement statements had to be used on just 1 to 4 family. The TRID, or now Know Before You Owe rules, I'd like to say KBYO. Say it with me.
KBYO.
KBYO. Ooh, I gotta laugh. Woo! It's a little bit broader. It goes to not just 1 to 4 family, but it's construction-only loans and vacant land, which was not under the RESPA rules. It was under the TILA rules, not under RESPA. Now they're together, so they're all under one guise. All right, so now we know what it deals with. Oh, by the way, don't you love the government? They said all consumer loans go under this, except a couple. So they kept out a couple of them. Reverse mortgages are still using the HUD-1 settlement statement. HELOCs, so home equity lines of credit, are still using the HUD-1 settlement statement and the old rules. Mobile homes and lenders with a low annual volume of less than 5 per year. If you're giving less than 5 loans a year, are you really a lender? So I think it's interesting because let's say a consumer is buying a house for $200,000. They're taking out a first mortgage for $160,000. That would be under the TRID or KBYO rules. But they need to get a HELOC for maybe $20,000. At the closing, the consumer is going to have a closing disclosure statement for the first mortgage and the HUD-1 settlement statement for the second mortgage for $20,000. That might be confusing. Thank you very much, CFPB. Nobody's from the CFPB in here, right? Right, and nobody's on back there, guys, from the CFPB? Good, right, good. Because I'm sure they could find me for something. I'm fairly certain. All right, so here's the 3 big changes that we're going to talk about. The new forms. Love the new forms. Love the new forms, Scott?
Like the new form.
And how many closings have you done with the new forms?
4.
And how has it gone as far as walking through the forms with the consumer?
Well, having done a lot of these presentations already, it actually is not, for me, it's not much different than the HUD-1 settlement statement. Once you get familiar with them, I think that's the key, is really just taking a look at it, visualizing the HUD-1 settlement statement, and taking a peek at the new closing disclosure, and you'll be able to get through it if you're asked to go over it with your client. So I mean, I don't see that it's any more confusing than the HUD-1 settlement statement was, so it's more or less just a matter of getting used to it.
So we got the new forms. We're going to talk about the new rules and timeframes. This is the key thing. The new forms are great. The new rules are difficult. The new rules say that the consumer, buyer, borrower, applicant, yes, all 4 terms are used on these forms, consumer, buyer, borrower, applicant, must receive the closing disclosure form at least 3 business days before the closing. And if they don't receive the final closing disclosure form at least 3 business days before the closing, you don't have a closing on those 3 business days later. You have to have it 3 business days before. And by the way, lenders are going to stick to this because the penalties are harsh. If the buyer receives the closing disclosure form 2 days before the closing, but the lender goes, it's fine, we can still go to closing, the lender is subject to a $1 million penalty from the Consumer Financial Protection Bureau. So lenders are not going to close 2 days after issuance and receipt of the closing disclosure form. And finally, changes the week before closing. Back in the day, we could do an amendment to the offer to purchase, the day of closing, modify the documents, you're good, still do your closing. That may not be the case in the brave new world, and we're going to go through a couple different examples of what we suggest. My biggest suggestion for everybody is before you, buyer, seller, amend the contract, please talk to the buyer's lender and say, will it affect my closing date? Because we've already had one at our company where buyer-seller did an amendment to the contract, didn't provide it to us as a settlement agent or the lender, and guess what happened? They did not have a closing on the day they thought they were going to have a closing because a new loan estimate had to be issued, and there had to be a wait of 3 days, and a new closing disclosure form had to be issued in a wait of 3 days because there was a change of circumstance that affected the loan terms. So to the extent you're helping out buyers and sellers, stop before you make any changes to the contract and make sure it works with the buyer's lender. So our first batter up is the new forms. New forms are the loan estimate. The loan estimate replaces the truth in lending form.
The initial truth in lending form.
The initial truth in lending and good faith estimate with a loan estimate. And then the closing disclosure form replaces the HUD-1 settlement statement and the final truth in lending form. So those forms are integrated into one 5-page form that we're going to go through. One thing I want to point out, though, these are going to be buyer forms only. Buyer consumer forms only when there's a loan transaction involved with the purchase. This doesn't apply to any cash deals. And as settlement agents and lenders will not provide these forms to the seller or the seller's agent or the listing broker, unless the buyer directs us to do so, because there's private information on these forms different than the HUD-1 settlement statement. So to the extent that you're helping out people at closing, there's actually probably going to be up to 3 different closing statements you'll see. There'll be the closing disclosure form for the buyer for the loan product. Number 2, there'll be a seller closing disclosure statement, and then there may be a number 3 integrated buyer-seller closing disclosure statement. And we're getting questions from lenders all around the board for any variations, so we may just be throwing paper at people and asking them to sign it with all the same numbers on them, but presented in different ways. So let's go into the closing disclosure. Again, it's a 5-page form. What you have in front of you here is the top half of the first page, and then we'll go into the bottom half of the first page, and then go from there on so forth. And Scott is awesome at explaining these, so please go for it.
Thank you. The way this works is, you know, I guess you think about the CFPB, and the idea behind the new closing disclosure, I'm sure, is that more is better, right? Well, to me, more beer in my growler is better, okay? More chocolate chips on my cookies are better, okay? I don't know if more pages are necessarily better, but it's what we have to work with, okay? And so we take a look at it and we make the best of it. And like I said, I don't have any problem with the way the new form is set up. I don't have any problem with this, with talking about it either, because I think what it does, back when the HUD-1 prior to 2010 was only 2 pages, you started at page 2, you took the total from page 2 and you carried it over to page 1. When the HUD-1 in 2010 went from 2 pages to 4 pages, you still started at page 2, and then you took the total from page 2 and went over to page 1 when you're trying to talk to your buyer about it. Well, and again, with respect to the HUD-1 settlement statement, you never saw any information about your actual loan until you either, at least in 2010, you got to page 3 on the lower right-hand side of the HUD-1 settlement statement, until you actually either got into the note or the truth in lending disclosure. The new closing disclosure form, obviously right at the top of page 1, it's going to have all the players involved, similar to the HUD-1 settlement statement. It's got the buyer, the seller, the type of loan product that's involved, the purchase price, which is actually kind of it's a small number shown on the closing disclosure on page 1, but it's also shown in other parts of the disclosure as well. But the top part of it really just has the players that are involved. When you're looking at the form then, what's the first thing that, at least my experience, what did the buyer want to know? What's my loan amount? What's my interest rate? What's my monthly payment? Okay? The other thing that's still not on the closing disclosure, which I think would be nice to have, but it was also not on the HUD-1 settlement statement, is the first payment date. Okay? It was never on the HUD-1. It wasn't anywhere disclosed until you got to the note. But I think the CFPB may have missed the boat here. If you're going to throw all this information onto the form, why not throw the first payment date on there as well?
And where I should send my payment.
And where you should send the payment, exactly. So if you're looking at the form again, the most important information, or the real sexy information about the loan itself, is right there at the top of page 1. It's going to show you the loan amount, the interest rate, your principal and interest payment, and whether any of that information can increase during the term of the loan. Also included on there is if there is a prepayment penalty and what it might be, and whether or not there's any balloon payments involved. Again, to try to satisfy. Yes, ma'am.
The date that you issued at the top, I'm assuming that's issued, but would that be the one that's 3 days into? Yes, that again.
Sure. That date at the top, date issued, does that need to be different? This is just a sample, of course, but is that one of the trigger places we should look?
This is the sample that was issued by the CFPB for training purposes. It's on their website. This is not Wisconsinized. And that's a great question. I've never had anybody ask that question, nor have I seen it addressed. I have piles of paper, so before you leave today, I'll take your card and I'll answer that question.
Okay.
But, you know, it's interesting because I'm seeing some of these closings that are starting now, and that issue date, that when the lender is preparing their closing disclosure, they're actually sending out a closing disclosure that may have a issue date that's only 2 days prior to the actual closing date. And so I'm not quite sure if the lender is actually issuing it properly, because I agree with you. I think that the date issued should be a date that's at least 3 business days before the closing. Okay, so I agree with you. And it's something that we're obviously going to have to at least touch base with the lenders about and say, hey, this date that you've got for date issued, we should really take a look at this and see if you're putting the correct date in there. You know, frankly, what is it, and we'll get into this in a bit, but what does it matter? You know what I mean? You've got a closing date. As long as everybody shows up, we're good to go. So anyway, getting back into the form itself, the other important information that they've got on page 1 is going to include escrow items for taxes and insurance. Okay, this would be the bottom half of page 1, and also whether or not PMI is involved. And so looking at the actual page there, it shows you in detail at what point in your payment years does your PMI drop off, and you're then just added to your monthly payment or your escrows for your taxes and insurance. Down a little bit further than that, you'll see a number of 356.13. Well, that's the escrow items that are actually part of the loan, and also escrow items, not necessarily escrow items per se, but items that you're also paying, in theory, on a monthly basis in connection with this example, that's not part of your monthly payment to the lender. So in this case here, it was homeowners association dues, or you could use condo dues or whatever. If there's monthly homeowners association dues or condo dues, it's going to be built into that total there, but it's disclosed here as not being part of your escrow item for your monthly payments.
We look at this as the Cliff Notes version of what the loan product is. Somebody can leave the closing with all the information of what it's going to cost them to own their house for the next 30 years. We all went to law school. How many people read the actual book or the smaller version that was out there? What were those called? I was thinking about them. I can't remember what it is. But it's a Cliff Note, yes. I love the property one, actually. That was my favorite one because the real property book had case law from 1600s and common law, so I had to go to the nub of it with the Cliff Notes version of it. It's extremely user-friendly. At the bottom of page 1, we have the costs at closing. These are roll-up numbers. We have closing costs of $97,1210. That's the closing costs associated with the loan itself. The cash to close of $14,147.26 is the amount that the buyer has to bring to closing, and that should be in a certified check or a wire transfer. As I stated, these are roll-up numbers. They come from pages 2 and 3, and we'll see them a couple more times as we walk through it. So if you are advising a buyer and they say, "How much? I can't get you the documents today. How much do I got to bring to closing?" No, the very bottom of the very first page has the cash to close, and that's the dollar amount that cannot change. Otherwise, a new CD may have to be issued. So we're at the top of page 2.
Top of page 2. And again, just getting back to that cash to close, again, the borrower in the new world now is going to have that number, in theory, 3 business days before the closing. So at the time that you're sitting down and closing, they'll have read this form, they will have seen the document. If they have any questions, obviously they'll contact you or contact their lender to go over it and review it. At the time of the closing, it really shouldn't be anything more than just saying, here are the numbers, does everything make sense, do you have any questions? Or you could certainly go through it again with them just to make sure that they've got a good understanding. But again, the key here is that rather than nowadays or prior to the new closing disclosure rules, customers were getting their numbers hours before a closing, sometimes the morning of. It made things a little bit more difficult, and tensions were a little bit higher at that point in time. But I think that's one of the benefits here is having this information 3 days prior is going to make the closing end of it much more smooth.
And again, most of these numbers were provided on the loan estimate, which was given to the buyer, almost 30 to 40 days before the closing takes place. There really should be very little changes, at least as to the loan numbers, and we'll go through the tolerance issues in a moment, from loan estimate to closing disclosure form. Top of page 2 actually deals with things that can or cannot change from loan estimate to closing. To the extent that you represent lenders, this is important.
What they're doing here on these closing costs is they separate them out. They separate them out from the loan costs that are involved with obtaining the funds from the lender and other costs associated with obtaining the funds. Other costs being prepaid interest, escrow items for taxes and insurance, and then just other items that you might have to pay, title insurance and things like that in connection with getting the funds. So up at the top half, just the things to point out here, the bold numbers at the top of each of the boxes are the totals of the numbers that are below them, okay? So the origination charges that are shown there, which are the numbers, the fees that would be going directly to the lender in order to obtain the funds from the lender. The borrower's got to pay origination charges. Those are bank-only fees. That total of those three items is shown in the bold above it. Below that,
Can I point out something on that? Those numbers, anything that's in the A, Section A, cannot change from loan estimate to closing disclosure. These are numbers that the lender can control. Lender can control its own origination fee, right? So the lender can't surprise the buyer at the closing and say, guess what, our origination fee went up 150%. Cannot change. If it changes, the lender eats that difference.
The other thing to point, and again, so just to kind of summarize the way these numbers work out, item D there at the bottom for the total of the loan costs is shown there at $4694.05. Well, that's just the combined total of those three items there, okay? But it also includes the credit report fee that was paid by the buyer outside of the closing. So again, take each of those numbers below the bold, that's going to total you up for that section's itemized numbers. The other thing to point out here is that title goofs and closing goofs like me really used to love the 800 section, the 900 section, the 1000 section. That's how we related to things. 803 is your appraisal, 804 is your credit report, and your flood cert and all of that fun stuff, okay? Well, things have changed now the way they've kind of structured it, and there's no longer 800, 900, 1,000 sections. The numbers are actually differentiated by the origination charges, and then services that the borrower can shop for, and that's when we'll get into the tolerances in a second. But the line items are no longer listed by 100 sections. Each of those individual sections has a 01, 02, 03, 04, and as that information is presented, it's going to just be presented in alphabetical order. So gone are the days of the appraisal, credit report, flood cert, things like that, tax service fee. It's all now kind of separated out by 01, 02, 03, all the way down, and each section's going to start with its own 01 and whatnot. And then those items are just alphabetized.
Going into Section A was origination charges, where it cannot change from loan estimate to closing disclosure. Anything that's in Section B, services the borrower did not shop for, can change by 10%. Cumulatively from loan estimate to closing disclosure. Anything in Section C, which is services borrower did shop for, can change as much as they want. If the lender says, hey, you're going to get a survey, it's going to cost you $500, borrower goes and gets a survey for $2,000, great. Borrower, you're the one that went and shop for it, and you found that surveyor for $2,000. So there's what they call a no tolerance or variance within that section. Another thing to point out is that this is all loan associated costs. So anytime here where it shows the title, lender's title insurance, anything dealing with title has to state title hyphen and then a description of it. Lenders are going to be very specific on terminology, because the CFPB has said you need to use this specific terminology. If you don't, that's potentially a $5,000 or $25,000 per day violation. So lenders will pay attention to that. Let's go to the bottom of page 2.
Really just dealing with the other costs associated with the transaction. Recording fees there, obviously prepaid items for the prepaid interest, funding the escrow accounts for the taxes and the insurance, any initial escrow payments that are going to be made, and then the other section, which is kind of the catch-all. Real estate commissions are shown there. If you remember on the HUD-1 settlement statement, that used to be right up at the top of page 2. Well, now they've kind of demoted the real estate commissions and said, okay, you guys will throw you down in the catch-all down at the bottom. But again, taking the totals of each of those boxed columns there, you'll have the total at item D for the loan costs, the total shown at item I for the other costs. Those two combined are your 971210, which, going back to page 1, summarizes the borrower's closing costs and prepaid expenses. Okay? So that's basically just the difference. You can actually start with page 1 now of the closing disclosure form and then make your way to page 2 and just kind of summarize the charges that way to the customer or to your client.
One thing I want to point out is here on this particular one, we see a seller paid column at closing, before closing. Lenders can choose if they want to have the seller paid numbers on the closing disclosure form.
If they choose not to have seller numbers on the closing disclosure form, which a number of lenders are choosing so, then by law, the buyer must receive a seller settlement statement that shows the seller-only numbers. Seller-only numbers would include like payoffs. Real estate transfer taxes would be a seller-only number. Commissions would be a seller-only number. This came as a somewhat surprise to us that there'd be lenders choosing not to show seller numbers on the CD or CDF form. And then we started thinking about it. We said, oh, that makes sense. So if there are changes just to the seller side, you don't have to reissue the closing disclosure form or redo the closing disclosure form. Oh, did we mention who prepares the closing disclosure form?
No.
We didn't. So in yesterday's world, the settlement companies, Knight Berry, would prepare the HUD one and provide it to the parties. In today's world, with the new TRID KBO stuff, the lenders prepare with us or prepare on their own the closing disclosure form, and they deliver to the closing disclosure form to the buyer to confirm receipt. And the reason they do that, because if they don't confirm the buyer's receipt, guess what's going to happen? Come on, you know the answer. There's going to be a big old fine, and it's up to $1 million.
Yeah, at least my experience in our office is it's sort of a mixed bag now between which lenders want to do their own closing disclosure and which lenders want us to prepare the closing disclosure, submit it to them for their review and approval, and then we use our form. In any event, for example, any title insurance company that's going to act as the settlement agent and cut the checks is still going to have to do the full disclosure from both the seller side and the buyer side as well. So we're going to have to prepare the whole form anyway because we're the ones actually cutting the checks and dispersing the funds. So we've got to still balance on the seller side as well as balance with the loan funds coming in from the lender. So we're still going to have one done anyway. It's just a matter of whether or not the lender wants to use our form or whether or not they've got their own form that they want to use.
All right, we'll go into this a little bit later. There's some goofiness with title insurance premiums in your packet of materials. There's a 2.5-page little memo that we wrote, and if we have time, we'll go through it a little bit more detail. But just know it's goofy. All right, top of page 3.
Top of page 3, we're really looking at what might be the first page of your HUD-1 settlement statement, just from a familiarity standpoint. Really, again, they're showing purchase price of the property, any earnest money deposits, loan amounts, all the type of information that you would see on page 1 of the settlement statement that actually then shows at the bottom on the buyer's side. Again, that $14,147.26, that's going to relate you right back to page 1 to show the amount of money that the borrower needed to bring into close. The seller's side, if the lender chooses to use the seller's information or include the seller information on the closing disclosure, it's also going to show the cash to or cash from the seller in order to settle the transaction. So this type of information here is very similar to what you saw on the HUD-1 settlement statement. The interesting thing, if you just think of it from a formatting standpoint, every once in a while you may see a closing cost credit from the seller on the closing statement, which would then transfer over to the HUD-1 settlement statement. And looking at the HUD-1, it would always be basically either on line 206 and then carry over to 506. There's my closing stuff again. But anyway, they would be lined up with each other as you go down. If it's going to be a credit on the buyer's side and a debit on the seller's side, it would show up on the same lines just all the way down. Here on the closing disclosure, it's not necessarily going to show that way. So if you're looking for a closing cost credit for your buyer from the seller, just be aware that it's not necessarily, you may see it on the seller side, but it may not be correspondingly directly across on the buyer's side. You might have to kind of hunt around for it.
I'm going to pop in here for people that represent lenders or lenders that are out there. If you look at section K on the left-hand side under borrower's transaction, closing costs paid at closing says $9,682.30. That number comes from the bottom of page 2 on the left-hand side, J, closing cost subtotals $9,682.30. I point this out because there's some software programs out there right now that are pulling not from closing costs paid at closing, but from J, the grayed out number of 971210. We've seen at least 3 lenders have a software problem pulling and integrating from the wrong location. So if you help out lenders, see if they have this problem with the software. We've tried to address it as much as we can, but the more we can get it out there that there are software problems, the better it is. And on that software problem too, another software problem that we've seen is, this is the top of page 4. There was escrowed property taxes over 1 year on the right-hand side of 2473.56. That would be the escrow for property taxes times 12. There's a couple software programs out there that think that they're apparently only 11 months out of a year, so they're multiplying by 11. So that would be problematic as well, because, you know, we're not in Greek time, which had 11 months, right? No, was it 10 months? I thought it was something like that. So
That I'm not aware of.
again,
I don't know.
somebody's going to look it up on their phone and we'll answer the question. Top of page 4.
The remaining few pages of the closing disclosure itself are really, majority of it is just that. It's disclosure. So they're really just showing, again, whether or not the loan can be assumed by a third party, whether or not the loan's got a demand feature, whether or not, what the late fee would be if the money is not received within the 15 days. Again, information that they're going to see in the note, but was just never shown in the HUD-1 settlement statement. Whether or not the loan's got negative amortization associated with it, whether or not the borrower can make prepayments. More so just disclosing more information that the borrower would have seen later on in the closing. They're just getting it out there right up front. The information here at the bottom then was information that was normally on the truth in lending disclosure. Over the term of the loan, how much money did you pay back to the lender? How much of that was interest? That APR, which would show the interest and the closing costs associated with getting the money from the lender, and how it didn't tie in with the actual interest rate. That was always the one big question that people would say is, that's not my interest rate. Well, you're right, okay? Initially, it used to be on the good faith, on the truth in lending disclosure right up front. Now they're kind of pushing that back and putting it towards the back of the document as a disclosure, but they still seem to think that it's important information.
I think this is top of page 5, the loan calculations. I think this is good information to know if I pay my loan on time, what are my total payments over my 30 years. I think this is great when we're talking about an interest rate that's set forth on this particular loan. The interest rate, if you recall, was 3.875%. So I take out a $162,000 loan. If I pay it every month on time for 30 years, my total payments is $285,803.36. Oh, I can live with that. I think it's going to be difficult in years to come. The Fed has indicated they will raise rates. It will happen in the next couple of months. And the rates are not going to just be 4% for the rest of our lives. They'll go up to 7% at some time. I always like to ask the question, and I think Mark won the one last time. What was your highest interest rate? And I was at 7.75% at one point. And Mark, I think you were up at 10 and a quarter. Anybody can beat Mark? 11. So during your lives.
Yeah.
14. So what would be $162,000 at 14% interest? You know, $1 billion. I'm fairly certain is what you have to pay over time. Also on page 5, you'll see on the left-hand side there's a box that says questions. If you have questions, please talk to the Consumer Financial Protection Bureau. I also like to call the Consumer Financial Protection Bureau the Complaint Bureau. They want to field questions and want to make sure that the consumer has a good experience and understands going through the process. The reason that's really important is at the bottom of page 5 is a list of everybody that's sitting at that closing table. Sorry, not you attorneys, because you're representing separately, but the lender has to identify who the lender is and provide all their licensing information. The mortgage broker, the real estate broker, as well as the real estate agent and their licensing information on both sides, selling side and on the buyer side. And then the settlement agent also needs to have all that information as well. And why is that? Because the CFPB has said right here, if you have questions, call us. We're here. We're ready and willing and able to help you, and we will find an answer and solution. So know that somebody raising their hand? Nope. Just know that that's kind of a new thing. We've never had to have all that information there. And the reason it's there is so that if the buyer ever files a complaint with the CFPB, all the CFPB will have to say is, give me a copy of your closing disclosure form, and they'll have all the information they need to contact and be able to resolve the concern of the consumer. At the bottom of page 5, there's an area for the applicant to sign the closing disclosure form. I love this, by the way. This closing disclosure form is what's presented to the buyer, borrower, consumer applicant at the closing. They're buying their house. They are taking out the loan. Are they still an applicant? And it says, by signing, you are only confirming that you have received this form. Great. I have a piece of paper in front of me. That's what the buyer's saying. You do not have to accept this loan because you have signed or received this form. And that language must be shown there in that particular font and in that particular location. You cannot change it. So nowhere here is the buyer saying, yep, I agree. I love this. I'm taking on the loan. And you, settlement agent, by the way, can go ahead and disperse pursuant to the numbers that are set forth here. So you'll see another number of title companies and settlement agents that are going to have another form that says, yep, I want to go forward with this purchase. I'm no longer just an applicant. That's the form.
You know, one thing to point out here on the form, and I ran into this question, it was posed to me, a fellow attorney who's representing a buyer asked me, Scott, the lender is calling me, asking me, because they know I'm involved with the transaction, they want to know what my fee is going to be, because now that they know that I'm representing a buyer, well, it's got to be on the loan estimate, and it's got to show up on the closing disclosure. And her argument or her position was, I don't know why I have to disclose this, because I may be, well, I'm representing this client on an hourly basis. I don't know what my ultimate fee is going to be, and how do we go about addressing that? Well, the lender was really adamant about it, and I believe what they ended up having to do is say, okay, here's an estimated fee that I'm going to charge, and get it in there up front so that they could do the disclosure, and then perhaps on the closing disclosure at the end, include that fee, and then anything that got billed afterwards, especially because the attorney was saying, I may bill this on an hourly rate, and number two, I'm not going to send my bill out until a couple of weeks after the closing's over. Yes, ma'am.
Wouldn't that go, couldn't they slide that right under C, services borrower shop for?
Sure, they can. I agree with you, and I think that's where that's going to go. I think the attorney's position, though.
The question was, can we slide that under C, the
Section C, that the
Section
services
C
that the customer can shop for. And again, to answer that, I think that's correct. It's just that the attorney is saying, look, I don't want to necessarily have any fee disputes with my client post-closing. When they get my invoice later on, I don't want there to be any confusion about, well, this number is the number that was on the loan estimate, this is the number that was on the closing disclosure, now you're sending me a bill for something a little bit more than that. So that's where I think the interesting thing, or at least the issue that's going to come up with attorneys who represent buyers. Some lenders are going to ask for that information, others may not.
And the lenders have an obligation on the loan estimate is to disclose as much information as they have as will reasonably be calculated to be shown on the closing disclosure form. So if the lender believes this is a fee that will be incurred, they must show it on the loan estimate, and it must be shown on the closing disclosure form. And in those buckets, the variations or tolerances, as we discussed, because it goes under different terms, by the way. In 2010, it was called a tolerance. Now it's called a variation. So the lender will be asking these questions to the extent they know that this is something that the buyer is going to incur as part of their purchase transaction. So now you've seen the new forms. That's the easy part. I think it makes a lot of sense. I mean, I think they're easy to read. There's some nuances that we don't necessarily love, but I think it makes sense, and I think a person is going to be able to walk away from that closing understanding what it is that they owe on a go-forward basis. But here's the new stuff that's going to cause some delays in your closing and making our closings go from 30 days in residential transactions from offer to closing to probably 45 days, and that's a number coming from lenders. Lenders are saying, we need more time, and here's why we need more time. These are the new rules and the new time frames. So the new time, oh, by the way, it shows 3-day disclosure rule effective August 1, then October 1, then October 3. These rules were supposed to go in place as of August 1st of this year. And then somebody told the CFPB, hey, CFPB, it's really busy in August. Can you delay? And they said, oh, okay. So they made up something. They literally said, oh, we forgot to submit something to Congress, so we're going to move it to October 1st. And then somebody said, CFPB, October 1st is a Thursday? Did you look at a calendar? And they said, okay, we'll go to October 3rd. So that's why we have an October 3rd date. Okay, I got a couple laughs off of that one.
That's good. Keep going.
All right, so now we're in October 3rd. So let's pretend we have a Friday closing. The rules say that the borrower, consumer, applicant must have the closing disclosure form in their hands and received at least 3 business days before the closing. A business day is all days other than Sundays and federal holidays. So if you're dealing with something over Thanksgiving, yeah, I think the disclosure has to be provided Halloween.
Probably.
All right, so Friday closing. Disclosures can either be hand-delivered, dropped in the mail, emailed. If they're hand-delivered, it's the 3 business day rule. And that is, so if your Friday closing, the lender has to give it by the preceding Tuesday. And that also would apply to electronic delivery if the consumer confirms receipt on that Tuesday. Let's confirm that again. It's receipt. It's not delivery of the closing disclosure by the lender. It's receipt by the consumer. So let's say you have a consumer, a lender that completes a closing disclosure form on that Tuesday and emails it off at 1 p.m. in the afternoon. But the buyer works second shift, has already left the home for the day, gets home at about 12:10 a.m. on Wednesday morning and says, yep, lender, I've got it, at 12:10 a.m. on Wednesday morning. Are you closing on that Friday? Nope. I mean, you could, but then the lender would pay $1 million to the CFPB. So most lenders are saying, we probably are not going to be able to hand deliver for the most part. We're probably not going to be able to courier the closing disclosure. We're probably not going to rely on the electronic delivery because we don't know when the receipt is going to be responded to. We're probably going to rely on what is the mail disclosures, which is the preceding Friday in our example. So the rule says 3 business days before the closing. However, if you drop it in the mail 7 days before the closing, that is calendar days, then you are deemed to have delivered it and the buyer is deemed to have received a closing disclosure form 3 business days before the closing. That enough? So let's go to the actual time frame here. So you know, the big lenders, the big national lenders have said, we are not going to hand deliver. We are not going to electronically deliver. We're not even going to rely on the U.S. mail service. We are going to drop the forms into the FedEx 7 business days before the closing. And the reason they're doing this, when I'm talking about the big lenders, this is Bank of America and Wells Fargo have publicly stated they're dropping it into FedEx, is because they want to have a consistent message when the CFPB comes in and audits them. Their compliance officers say, we can tell the CFPB that every single transaction, we drop in the CD in the FedEx 7 business days before the closing. It's a great statement. And then periodically, if you have to make changes, they can still rely later on. If you want to change the CD form, they can still email it later on and confirm receipt later on if there are changes that necessitate a new issuance. But at least they've dropped it in the initial one in the mail. So let's talk about a 30-day close. Can we get to a 30-day close?
All the stars have to be in a line.
All the stars have to be aligned.
It's unlikely nowadays, I think.
So you have a closing on the 31st, Friday the 31st. You all love Friday the 31st closing. And I want to tell you right now, Nightberry has cookies in most of our offices on Tuesdays and Wednesdays. Please schedule.
As an incentive, obviously, to stay away from Fridays.
It's not a thing of value I'm giving you here, not a RESPA violation.
No.
Just cookies with a lot of chocolate chips, right, Scott?
Mm-hmm. Plenty.
Okay, so you have a closing on the 31st. The lender must drop in the CD at least 7 days before the closing, so by the 23rd, they're going to drop the CD into the FedEx on the 23rd. In order for them to be able to drop that CD in the FedEx on the 23rd, they must actually prepare the CD by the 22nd and have it done. In order for the lender to prepare the CD, because again, lenders prepare the CDs, not the title companies, they must have the seller-buyer numbers to be able to incorporate with their loan numbers. In order for them to have that by the 22nd, well, the title companies, Nightberry, are still going to prepare the seller-buyer numbers. Lenders are not taking on that role. They don't want to take on that role. They still want to rely on us. So for us to be able to prepare those numbers, well, we must have had to prepare seller-buyer closing statements, delivered it to all the people involved in the transaction, buyer, seller, realtors, attorneys, and get some approval. So we probably need to have that done by the 17th, get it to you over the weekend, get some approval so we can send it off to the lender. In order for us to be able to have that done by the 17th, we must have received the seller payoff numbers. That would be helpful. And be able to get the seller payoff numbers for mortgage loans. It's by law, lenders have 7 days after request to be able to provide us a payoff number. Couple things here. What if there's not just mortgages on title? What if there's like a, I don't know, federal tax lien?
Has anyone dealt with the IRS trying to get federal tax lien payoff letters? It's not very easy, is it? No.
So this is why you may see some lenders choosing not to show the seller numbers on their CD, because then they don't have to worry about the payoffs. They don't have to worry about the feds that take about 45 days, is my experience, to be able to provide a payoff statement. But if the lenders do want to show the seller numbers on the CD, well, then we need to get the payoff information. In order to get the payoff information, well, we must have ordered the payoff information probably by the 7th. In order to be able to know who to ask to get a payoff, we need to have title work done. In order to have title work done, you need to place the order. And if we're talking about a lot and block in the city of Milwaukee, we can produce a title commitment pretty quickly. If we are talking about a meets and bounds legal description in Walworth County that hasn't transferred title in 100 years, I have Jen sitting over there right now. We had to deal with a cemetery in, which county was it, Jen? Vernon. Yeah, she knows it by heart. She could tell you everything. We had to go back to patent for this transaction. That took more than 3 days to be able to produce the commitment. So depending on what you're talking about, we need some time to be able to do this, to be able to get to your 30 days. We need to be able to order title. We need to be able to order payoffs. We need to be able to get the parties. We need to get their consent. We need to be able to get it to the lenders and get it to the lenders so that they can drop it in the mail by the 23rd so they can get it by the 31st closing. In today's world, we're preparing, in September world, we're preparing the HUD one on the 30th.
Many times. Sometimes on the 31st. Sometimes on the 31st, yeah.
There's a question.
Question from the web with 2 follow-ups. Do these rules and required forms apply only where there is a mortgage loan?
Correct.
Example, the sale is a cash sale with no loan of a parcel of vacant land. Is it required to use the new forms?
These new forms, here, the CFPB is concerned about consumer lending, so it only applies when there's a consumer loan. By the way, the CFPB just doesn't deal with just mortgages. They control all types of consumer lending. Student loans are under the guise of the CFPB. Car loans are under the guise. Credit cards are under the guise. All of that. So it's anything where it's a consumer loan is controlled by this, and here we're talking about mortgages.
So a simple attorney-prepared old-school closing statement would work?
Napkin or a text, I think, is just fine.
Well, and again, I think that's where it comes into play with attorneys who represent sellers nowadays. Attorneys that represent sellers can still prepare their closing statements. Other title companies are still preparing buyer-seller closing statements and submitting them to us or to the lenders to prepare the closing disclosure form. So the closing statement on the seller side has not necessarily gone away. Some title companies choose to prepare seller disclosures that only have seller numbers on them. But where it's important to attorneys representing sellers is that your time frames now here, in theory, are pushed up a heck of a lot, okay? In order to, in theory, under this rule for a 30-day close, your final closing statement would have had to have been done, in theory, 2 weeks before the closing, okay? Which is a lot sooner than we're normally accustomed. And I remember that, okay? So it's order my payoffs a lot earlier and order special assessment letters. The suggestion, again, is just we're picking up the pace on a lot of this. So, and then dealing with clients who, when you order a payoff letter, for example, early in the month, and then they make their payment after the date that the payoff letter is received. Now, again, there are ways around that that wouldn't necessarily delay the closing, but again, it's just things that we have to realize.
All right, so we've said the title can close in 30 days. Can the lenders close in under 30 days? This is straight from Associated Bank. I did a presentation with them. They said, Cheri, great, thanks for that 30 days. We're not doing 30 days. We're doing 45 days. And here's why. All of this stuff needs to be completed by the lender before. Most lenders are saying, in my experience, they will not issue the CD until there's a clear to close. And the reason is they feel like if they issue the CD and there isn't a clear to close, that's kind of a misrepresentation to the buyer. You're kind of, by issuance of the CD, you're promising the buyer you're going to get to closing. So here's things that the buyer needs to have done or needs to be done before the clear to close is provided. By the way, sometimes in the old world, did you have clear to close before you went into your closing?
Occasionally.
Occasionally.
Oh, you always had clear to close before you went into the closing.
I've heard many people said that we sat in closing, they signed all the documents, they still didn't have clear to close.
Yeah.
And that's like at closing.
Not Scott, Cheri.
I'm not, yeah. We generally had clear to close. We were comfortable with closing. We had comfort to close. Let's say that. No. Okay.
Homeowners insurance. I mean, the problem is we would see homeowners insurance get bound the day before closing. Buyers, if you're representing them, tell them as soon as they have their offer to purchase, this is where you go. Number 1, to your lender. Number 2, to get your homeowners insurance bound, period. Because then you're not going to have that as a bar to closing. That's something that the buyer can control. Sellers' closing statements, we already talked about that. It's a pushback. So buyers, sellers, as soon as you get the seller closing statement, which you'll receive like 2 weeks before closing, you're like, what am I getting this for? 2 weeks before closing? Well, you need to be able to say, yep, these are approved, so that we, as the title company, can get them over to the lenders to prepare the CD. MI certificate, that's the mortgage insurance. That's in the control of the lender, but that may take some time. The loan payoff, we talked about that, but again, if you're not just talking about mortgage loan payoffs, but things more like federal tax liens, it could add a little bit of time. Title insurance, appraisal, and rate lock. By the way, appraisals, I'm hearing, are 3 weeks behind or so in our area. I have a nod over there. So that's pushing it back. So let's say you got offer to purchase, lender, 3 weeks to get to appraisal. You're not closing in 30 days because you still have to have the CD issued 7 days before the closing. So ask the lender. I would suggest that the buyers talk to their lenders and say, if I do this offer to purchase, what's a reasonable time frame that I can use for a closing date? Is it going to be 30 days? Some lenders are saying 30 days is okay, but then buyer needs to make sure all their ducks in a row. All right? So there's 3 different things that necessitate the issuance of a new closing disclosure after the lender has issued the closing disclosure and they're waiting their 3 days. The first is if a prepayment penalty is added to the mortgage loan. Does that happen?
Not anymore. Not that I've seen. I haven't seen a prepayment penalty in quite a while.
I'm not concerned about that. So this was in response to 2006. People would go into closings, buyers would go into closings, and they're like, why is that prepayment penalty on? And then the lender would, whoever was there would say, well, if you want to buy the house today, please sign it. So that's not allowed anymore.
That's if the lender was there.
Yeah.
A lot of times the lender wasn't there. But.
The change in the product type from a fixed to an ARM, again, that was a 2006 kind of thing. I thought I was getting a 30-year fixed. Well, we couldn't quite get you into that loan product, so we gave you a 5-year ARM. Yeah. Do you want to buy the house today? Go ahead and sign that.
You know what, although, I mean, sometimes now lenders do what are known as soft pulls right before a closing. So occasionally they'll see something, or there may be some circumstance where even closer to the closing, they find out that for secondary market purposes or whatnot, the loan just can't be approved in the type of product that was initially offered. So they'd have to move them to an adjustable rate. Very rare, doesn't happen at all very often, at least, but I have heard lenders say we've got to move to an ARM loan. And so that is one circumstance that could require a new 3-day disclosure. But again, perhaps more frequently than the prepayment penalty, but not very common at all.
So in that particular instance, if there's a change in circumstance, which is a legal term under the Dodd-Frank rules, there may have to be a new issuance of a new loan estimate, right, and you have to wait 3 days, and then a new closing disclosure form, which waits another 3 days. So that could be problematic.
Sure.
And the other thing that requires a new issuance of a CD and a wait another 3 days is the change of the APR by more than an eighth. And in some instances, it's a quarter, depending upon the loan product and the dollar amount of it. And there's some discussion out there if it's an eighth up or an eighth down may still require a new 3-day waiting period.
So even though it's benefiting the borrower in theory by reducing the APR by more than an eighth, at least one school of thought is, well, it still requires the new 3-day disclosure.
Beyond that, things can change the CD within those 3 days before closing. The lender still has to issue a new CD, but you don't have to wait 3 days. So let's talk about the changes the weeks before closing. Again, I urge you, don't make any changes the week before closing without first talking to the lender, making certain you can still preserve your closing date, because here's some problems. And this is coming, the realtors, this is what they're facing.
Can I do number one?
Yeah, please. Number one. You do?
Yes. Well, this is, especially because this is the first question, or most of the time, the questions that I would get from the realtors. The realtors and even lenders were under a misconception initially when these rules came out. Their thought process was, oh my word, anything that changes with respect to the transaction from the time that the closing statement is done is going to require a new closing. You can't close anymore if there are any changes at all made. Well, no, as we just saw.
And because it used to be, when the forms were first issued, about 2 years ago, it was any change to the buyer side by $100 or more.
Well, that's what the initial one was?
The
Really?
$100, and then everybody went, wait a second, things change.
Yeah.
Come on, give it a look, and that's where they moved it to an eighth.
Yeah, so the question then becomes, for example, in bad thing number 1, 2 days before the closing, after the closing disclosure was issued, the borrower sees scratches in the floor and gets a $1,000 credit from the seller. The question is, the $1,000 credit from the seller, does that require then a new disclosure and then waiting another 3 days to close? Well, if you look at the elements of what items are going to require it, probably not. There's no prepayment penalty that's being added. We're not changing the product from a fixed to an arm or an arm to a fixed, okay? And the APR is not changing by more than an eighth. Maybe not, okay? But the underwriter, the lender's underwriter has to review that change because it may impact, depending on the size of the loan to value, debt to equity ratios that the lender kind of fixes into their little box. This closing cost credit may affect the APR, may be unlikely, but it may affect the APR that would require it. I think it's unlikely that it's going to happen on a dollar number, but again, I think it's a factor of the loan size in connection with purchase price and things like that. But typically, something like this doesn't ordinarily or may not, on a typical basis, require a new closing disclosure be sent out.
And the lenders are really looking about credits here. Here we're saying that the lender has to verify that the credit doesn't exceed 6%, which is a general credit. Some credits are 3%, 6% to 9% that the lenders have, allowing credits to the buyer from the seller, depending upon what the down payment is from the buyer. So talk to the lender. If that seller, thank you. If that seller has already given the buyer a ton of credits, if you add on another $1,000, that may exceed it, and you may be out of that particular loan product. So again, talk to the lender, and then you can get your answer. Is this credit a problem with the loan product that I have?
I think
Yes.
this question is directed right at you.
I would imagine.
If there's a drop in the price instead of a credit, considering the fact most lenders will not let you give a credit, if you just drop the price of the property by the equivalent of credit, would you have to
Well, if you drop the
redisclose
price, you're not changing the loan product. However,
Loan to values may be an
Yeah.
impact
Right.
then, and you may have to adjust the loan amount,
Right.
which may change APR.
that? Yeah, if you had an 80% loan.
That's correct.
It may be
Reducing the
blown.
purchase price might impact that loan amount. You
Right.
might have to change the loan in order to stay within the 80% loan to value, and that may change the APR.
lenders really like credits. They think that this is the best way to resolve, I mean, in my discussion with lenders, the best way to resolve these issues the last week of closing is to give credits. However, being cognizant that they may exceed their credits that they're allowed to be able to sell this loan on the secondary market. All right, bad thing number 2, the sale of the borrower's current home blows up in the morning, delaying a purchase closing from November 30th to December 3rd. All right, so we have the CDs already been issued. Now we have a delay closing from November 30th to December 3rd. Do we have to reissue the CD and wait 3 days potentially? Well, let's talk about it. Is there a prepayment penalty added? No. Is the product changed? No. APR probably should be the same unless the sale of the borrower's current residence is for less than they thought they would have, and now they don't have enough money, and now you got to change the loan product because your 80 to 80-20 loan to value is off. That certainly could affect it. So talk to the lender. See if you're going to actually be able to close December 3rd. If your loan product changes, then you might have to get a new loan estimate issued, wait 3 days, new closing disclosure, wait 3 days. One thing that you want to point out is there's a new contingency form that the realtors created called Addendum TR. How many people have seen it? And if you have, there's one person there that has seen it. If you haven't seen it, give me your business card. We can email you a copy. I'm sorry we didn't include in these materials. It's an addendum that you're going to start seeing. Buyers like it, sellers don't. It's an addendum added to the residential offer to purchase form. It's not issued by the Department of Safety and Professional Services. It's a WRA form itself, which says if the closing is delayed because something dealing with TRID, basically, the buyer can unilaterally tell the seller, we're pushing the closing date back up to 7 days or 10 days or whatever the inserted date is. Buyers like that.
because they're protected. They can still buy the house. A seller may not like addendum TR because let's say if November 30th is an important date for the seller. Seller needs to sell November 30th because they're buying another house in California on December 1st. Seller's not going to like it. There's going to be some friction between buyers and sellers using that particular form if the closing date is important to the seller. You want to do bad thing number 3?
Sure.
Or we're almost done?
Almost done.
Okay. Number 3, we're really just talking about a potential escrow, post-closing escrow for a broken window in that case, and would that require a new 3-day wait for the closing? The elements of those items that would require the 3 days are not present, but lenders would, number 1, want to review the escrow agreement to make sure that it meets their specifications. They would want to approve it. Some lenders want to be part of the escrow agreement, or party to the escrow agreement. But typically, though, some lenders would prefer, rather than see the escrow agreement, that the credit be given to the buyer at the closing on the closing disclosure, or that the seller fix the work prior to the closing itself. So, again, it's one of these things where we're just repeating the idea of contact the lender. Anytime an issue comes up, make sure you contact the lender to see what they're going to require and whether or not your potential solution is viable on their end.
So we're hearing from lenders they don't like post-closing escrow agreements. They think it's let's say it's in this case, a $1,500 for a broken window that is going to be held by the title company until the window is fixed. If just the seller and buyer are on that escrow agreement, seller could authorize post-closing that the money be released to the buyer. It could be a way to funnel money to the buyer, which essentially is a reduction in the purchase price. So lenders don't like post-closing escrow agreements unless they're joined onto them, or if it relates to a weather-related issue. Lenders are okay for the most part if it's December or January in Wisconsin and the seller was not able to put in the driveway because it's January or in Wisconsin, that you can hold back some money until May and get the driveway installed. But for these smaller issues, lenders are for the most part saying, go with the credit. Now, if I'm the seller, I'm not so happy because I don't know the exact dollar amount to fix that window and I don't want to have to overpay. So there's going to be tension between the seller and the buyer in that as well. All right,
Okay. Go ahead. We'll get one more of these and then see if we've got any questions.
Okay.
Okay.
All right, bad thing number 4, co-borrower can't make it to closing. Power of attorney is set up the day before closing, but after the lender issues the CD. Is this a problem for your CD? It's not, because it doesn't affect the loan terms, but it is something that we are encouraging that the sellers and buyers and tell their lenders earlier rather than later, because the lender certainly is going to want to review that power of attorney and make sure that the right people are coming to the closing and signing their loan products.
I think one other thing just to kind of point out is if something changes on the closing disclosure that doesn't require a new closing date, how does it happen? In the old days, I would just get a new closing statement from the seller, for example. I'd run back to my office, fix the HUD, send the HUD over to the lender to say, hey, this just changed on the seller side. We're increasing the seller credit to the buyer, and send it over to the lender. They'd say, okay, HUD approved, and I'd be back in there closing that transaction. 5-minute delay on a closing, for example. Nowadays, though, with the advent of the new closing disclosures, does it still close that day? Yeah, probably. It would close that day, but what would end up happening? Well, the lender would have to get the new seller statement to show what the change is. They'd have to make sure that it doesn't affect the APR by, for example, more than 1/8. And if it didn't, then the lender would generate the new closing disclosure and get it to the closing. So it may delay things a little bit just because of timing, but you still close that day. It's just the process might be a little bit longer. There may be a little bit more of a delay than 3 weeks ago when we would just simply punch out a new HUD and walk right back into the closing and recut some checks.
So the problem's week before closing, what can you do? Change the purchase price, post-closing escrow agreement, credit to the buyer, pay contractor. Cash under the table is here, because after one of these presentations, somebody came up to me and said, hey, we're thinking of just creating a new form that'll be just seller-buyer, will allow us, the seller, just to give money to the buyer, and we won't provide that to the lender. Do you think that's a good idea, Cheri? Yeah. So I just stared at her.
Not a good idea.
No.
Not a good idea. Any questions here? Any questions for any of our presenters today? This is your opportunity here.
I'll ask the question. So, I mean, I think all of us have had the experience where you're representing a family and they sell at 9 o'clock and they buy at 10 o'clock. Based on my limited experience thus far, it seems to me that prudently you're not going to have people scheduling same-day closings because there are just too many potential issues. So I guess I'm curious what you're seeing, and is there some new industry for homeless people? They sell 7 to 10 days before they're going to buy.
Well, the post-closing occupancy agreement, which is a standard form in Wisconsin, we're seeing that used more. That new addendum TR does contemplate if the closing blows up because your lender can't get the stuff done on time, or if you're selling a property and that buyer's lender can't get the stuff done on time. So I would certainly look at the addendum TR and invest in pods. I think that's what you should do right now.
So whoever the first guy is in the chain of, if I'm selling, but they have to sell, but they have to sell, but they have
Right,
to sell.
so I mean, if deal number 1 blows up, unless deal number 2, 3, or 4 have a wheelbarrow full of cash that they can then say, I'm just going to pay cash for this thing, it pushes everybody back. Now, that potential could happen still today, but more so today, it's more of a redisclosure thing, change the HUD, walk back into the closing, and away you go. Unfortunately, if that redisclosure results in a different a change in the APR, it's just not happening. It's just not happening.
Okay. Look, another question? Good.
Let's say that you have an example 4 or 5, I think. You talk about the prepaids changing the numbers. What about issuing a credit to the buyer for those numbers so that they don't change? Or can that not affect that? I don't know if I'm explaining that well. Prepaid, so if you're closing December 11th, it gets bumped back by a week. Your prepaids change, it affects it by a rate of 1/8. Is that an area where the seller can offset and put it on a seller side, or voluntarily pay those, or?
I've heard that as a solution, and I would always advise talk to the lender first and make sure that that works with them as well.
Okay.
Okay. Good. It looks.
Good question.
We've got one more. All right. Good.
How has this affected the funding number dance? You know, have the lenders changed what they require of you to disperse?
No, it's still, they still want to make sure that we've got the documents signed properly, and so it's still submit the funding documents, the required funding documents. It's just another form.
It isn't since they prepared the document, isn't their review of the closing disclosure quicker than just seeing that it's signed rather than?
Well, no, because but the thing is that the lenders not only want to see the closing disclosure, they want to make sure that I had the note initialed and signed properly, the mortgage initialed and signed properly. So it's more, I think it's more execution of documents is why they're looking at from a funding standpoint.
All right.
I know that lenders aren't used to preparing these. So they really are staffing up and learning the process as well. And as we stated earlier, some of their software is even wrong. So we're glad that October 3 was the date this was implemented, other than August 1st. That would have been really problematic for everybody going to school in Wisconsin and trying to move and getting in the school district.
Michelle, to your point, I've got one the day after Thanksgiving. I'm closing a purchase transaction where my understanding is that the seller is she's selling at 1 and then immediately going to purchase on the day after Thanksgiving. I mean, I'm not quite sure why that's working, but it'll be interesting to see. I'm not involved on that second half, but we just cross our fingers and hope that there aren't any issues on the front end.
Okay. I'm going to call it a day today and say thank you very much for coming. I want to thank Michelle and Mark and Scott and Cheri for their time and their effort this morning. I think it's been sobering for me a little bit here, but hopefully helpful in all of that as well. So thank you for coming, and hope to see you again soon.
Very good.
And if you all have a chance to fill out the evaluation form in the back of your book, that would be extremely helpful for us. We take your comments very seriously. Thank you.